Hello, lovies. Happy Friday night. It is October 11th, 2024, and I curled my hair. Okay, I'm just saying. All right, so we know that this is big doings tonight. We have the incomparable, the extraordinary legal mind of Mr. Mark Bederow with us this evening, guys. And we're going to cover a lot together. Why? Because he's my best friend from New York. Okay, don't make it weird. I won't either. So we're going to talk about our supper. We're going to talk about, Karen Reed and some questions that I may have for Attorney Bederow. And then we're going to go into Enrique Delgado Garcia and our thoughts and feelings that may be presented on that. And guys, if you have any questions for Mr. Bederow, do me one solid, because I can't follow a chat to save my soul. Just put the question in, and then I will go through them at the end of the stream. Okay, I'm going to pull a little page out of El Jefe's book tonight. Okay, and with that being said, without further ado, my best friend, whose face I love, who got a haircut. I don't know if it was for me, but I'm just saying, here's Mr. Mark Bederow.
Hi.
Hi, Mr. Bederow.
Did get a haircut.
Oh, he did. And I curled my hair. So, these are things that we can just say together that, I would only curl my hair on a Friday for Mr. Nurse Kim or Mr. Bederow, and somebody got a haircut. I'm not making a correlation. Mrs. Bederow and Nurse Kim, I don't know. Who am I? Just a friend from the internet. So, Mr. Bederow, tell me how your week has been. I've missed you. We haven't seen you on the web. You have not been on shows. You have been busy, being a legal genius in not only New York State, but also the Commonwealth of Massachusetts. Tell me everything.
Nothing, not much, just busy week, but generally nothing crazy or interesting. No trips to Massachusetts this week, but there's certainly, I think 4 planned over the next couple months, because, when people get charged with crime after crime after crime, you have to go back a lot. So I'd expect to be there a couple times, in November, a couple times in December, January, God knows how long beyond that. But I'm here working, living, grifting, all of it.
All of it.
Yeah.
Also, I did want to say that I saw a photo on X that was concerning to us all. It was your child and your young, beautiful, charming daughter, and I believe Winnie in a crate. Is that accurate?
That was Winnie. Winnie generally doesn't wander into the office. Yeah, Winnie does her own thing. But Winnie, we don't call it, it's her house. Door is never shut, by the way. But she loves her house. And when we eat dinner, or hang out in the dining room, depending on what's on the table, because Winnie is a lab, and anybody who has a lab knows anything on the table is fair game for an 80-pound canine vacuum cleaner garbage can. So if we just kind of block her out, she'll just go in her house and stare at the window with those sad eyes. And so, she jumped in to hang out with the dog, and yeah, they looked like they were in jail.
It was adorable. Okay. Lock me up and throw away the key. I know you don't shut the door, but they're 2 cuties. I can't handle it.
We never shut the door on the dog houses for the dogs.
Of course. So speaking of when you're at supper and probably a golden retriever, perhaps I was the golden retriever of our supper that we had just a couple of weeks back at the Capitol Grill in Dedham when you were up here for a legal case. We may not say which. And we had, I don't know about you, Mr. Bederow, but it was top 5 best suppers of my life. And it was incredible to meet you IRL.
It was good. Good food, good wine, good company. That's what you want in a good meal at a good place. So yeah, no, it's great. Loved it. Not sure why it offended so many people, but it was a great time with good people. It's not a radical concept to go out and enjoy life. And if that bothers certain people, that's on them. It was fun.
Yeah, no, it was a great time. And I felt like us having that opportunity to connect with one another, because we've become close, in my opinion, through this whole ordeal and through our digging in the Commonwealth. And I think that it is imperative for us to continue to make the bonds. In my opinion, I find no harm or foul in us being together.
Foul. I see what you did there, like with the foul behind you. Yeah. No, I don't know why people eating dinner who enjoy each other's company would be so triggering to so many. But that's part of the whole group of people that somehow are obsessed with this, who just get angry and, live their life online. And, whether there's just some bitterness, I don't know. I'd rather be out with people having a good time than, home alone with my laptop in the attic. But that's just me.
I totally agree. And it was interesting because I think a lot of people did have a misconception perhaps as well, that like we all did know each other, because we kind of are, either you're on my channel often, I've been on the Young Jerks with Mike frequently. I've been on Maz's channel. I went on we're kind of like a community that speak with one another. And I thought for sure that you had met the boys like multiple times. Not me. I mean, I knew it was I was like, oh my gosh, I'm getting invited. But
No.
The boys, I thought you guys had been out many a time.
No, I had never in person met. I mean, we were online people, but it was great to meet everyone and to do it again. And some of us have even had dinner at Kowloon since then.
Yeah, I'm not going to have a comment on that, because I clearly believe I made a story in my brain, Mr. Bederow, that was boys' night. Okay. And that was the only reason that Nurse Kim was not invited.
So,
it could have been. It could have been. And now Mike is down with the COVID. So we're trying to wish him all the best for him to feel better. And he told me that he has all of the Gatorade that he needs. So I didn't have to DoorDash him anything today, but I was willing to, because I'm a real nurse. I don't just play one on TV.
Well, apparently the spreading event was not dinner at Kowloon, because I don't have COVID, fortunately. Feel good. Hopefully everyone else does, and might get better. That's unfortunate, but it's a couple days down and then you get back.
I know. I've had it. I think I told people last night on my stream that I feel like I've had it maybe 5 or 6 times, since 2020. And each time I think it's a little bit, less. We don't need to get into it, but it's whatever is going around for what your symptoms are. And it is, a lot. And some people take it differently than others, but unfortunately it will be around for the foreseeable future. Yeah. And we have to kind of get used to that. So, all right. So now let's move into, well, wait, what did you eat? I wanted to know, because I was on the other end of the table. If we go back to where I walk in, I think I'm on time, everybody. And I was on time. However, I was one of the last people to arrive, and I was there at 7:00 when dinner was to be there at 7. Wow. So I'm sitting down at the end of the table with, it's like myself, it is Meredith. Then there was TB. And then on the other side, we have Paul Cristoforo. And then we had Kelly Reed, the lovely and talented. And then next to her was Richie. And then on this side of me was LTL. And then next to him was Maza. And then you were at the other head of the table, as we know. And Mike Crawford was next to you. And the Glare was next to you. Is that correct? Oh, no, Nathan was next to you on the other side. And Nathan. Then the Glare next to Nathan.
Wow, that's pretty good memory. So I'm kind of a steakhouse connoisseur kind of guy. To me, it depends on what kind of steakhouse you go to. If you go to what I call a Peter Luger style steakhouse, where it's just how many people, that's going to be porterhouse, medium rare. There's no debate. That's what you get. That's what it is. But when you go a good one like a Capitol Grill, where it's kind of more on your own, it's filet medium rare. There's nothing else. I don't even look at a menu. Filet medium rare with a glass of Cabernet, always, and sauteed spinach.
Oh, I love that. Okay, and I got, on recommendation of Meredith O'Neill, I got a filet, but I got it Oscar style, which I had never had because I'm not a fancy broad. Okay. But I loved it. I thought it was great. It was like crab meat, right?
Yeah, but I mean, if I go to a Luger style place too, which is it's Peter. If you're ever in New York, it's like Peter Luger, Wolfgang's,
Oh, yeah.
Ben X, places like that. Another must-have is bacon, and when I say bacon, it's not like breakfast bacon. It's a slab of bacon that's an inch and a half thick that takes a steak knife to cut it and is feels like it's like 8 or 9 inches long and it's thick. It's great. So, but yeah, that's definitely something else you want to get at a place like that.
Okay.
Always
I'm going to put that on my list.
That's it. Filet or porterhouse, nothing else. Medium rare.
You're a medium rare type of guy.
Only way to eat steak. You should never eat steak. None of this well done with ketchup. None of that. Can't have that.
My co-host, formerly known as Dave Cullinane, only eats his meat well done, which is offensive to all of my senses. But I'm a medium girl. I can't do medium rare.
Yeah, medium is bad enough, but if you're getting steak well done, you're missing the point, and you don't even bother. I mean, shoe leather is at that point an equal option. That's
makes me
well
think
done.
that he should have never gone to any dinners with humans that had steak then, because if he likes his steak in a well done format, that seems inappropriate to the gods of beef, right?
You might as well just have ground chuck if you're going to have it well done, not fine steak, not prime steak.
Absolutely.
Terrible. That is a crime against steak.
That is a crime. And if you're going to do it, at least do it right. Is that what we say? If I'm going to do it or try it, I have to do it the right way. But I didn't know that there was a rule, or you were supposed to have it medium rare. I think I would have been slightly offended if it was like, is it cold? Is it cool inside? Because I need it to be warm.
No, medium rare is just little, little brown on the edges and pink in the middle.
Okay.
Perfect. No,
all right.
Rare.
I can do it.
Rare is going to be a little chewy and potentially not as hot. But
okay.
Well, I mean, to me, even medium steak defeats the point. That's just not going to call that a crime against steak, but no, that you're missing the experience. Might as well go vegetarian though if you're going to eat it well done.
Yeah, that's probably like a ticket, right? You're getting a ticket for that, but not sent directly to jail.
That may be something, right?
Okay.
Right.
All right. So we had that. Was there any specific people that was your favorite to meet that night?
Specific? No, I thought the whole crowd. Well, obviously, Nurse Kim. I missed the trigger. No, come on. No, it was a great crowd, and the reality is, you could have made it 10 or, oh my God, like she fell off the chair. We could have had 10, 15, 20, 30 more people if there was time and availability. But no, it was a good group of people. Everyone enjoyed everyone's company, and we'll do it again next time.
I agree.
Yeah.
I love that. All right. And now I would like to ask you, Mr. Bederow, because every YouTube channel has gone over some bombshell filings that were filed by you. Okay. You smart and handsome man. And I know that it is not appropriate for us to comment really directly on the case, but I was hoping that we could discuss generalization of why in the Commonwealth of Massachusetts it is best practice and is required by our legal system for you to request material evidence, and basically material evidence, you have to request it initially, and then they would go to a different procedure if not responded to appropriately by either the DA or in this case a specific potential informant.
So it's not really a Massachusetts thing. It's customary that the prosecution is required to disclose various categories of evidence to the defense. And it is entirely customary for the defense to make demands for certain forms of evidence that you're entitled to or you believe you're entitled to. And it is entirely customary to do that in a way in which you write them and make a specific demand. You document it. It's on the record. It is entirely customary, depending on the nature of the case, to send a copy to the court file to keep the court aware, because there could be potentially a controversy or an issue. And it helps to have, as you saw in the last court appearance that we had, a judge who was really up to date on everything. Newsflash, she was up to date because copies of letters were sent to her outlining the issues. That's kind of the point in letting the court know. So what you do is you notify the prosecution of what you're entitled to, what you think you're entitled to, and they respond. And they can respond in any number of ways. They can disclose evidence, which is often the case, or they can respond by saying, we don't have it, we don't think you're entitled to it. But either way, you're getting a record of a response, which then would allow you to document that position of yours and theirs, and if necessary, file an appropriate motion demanding a remedy from the court to make a ruling, or potentially, if it turns out that there is evidence that you should have received that you didn't, and they said they didn't have it, but they did, you may be seeking sanctions or other things later. So it's entirely normal to write discovery demands to prosecutors. Now, you could do it in any number of ways. You can write a very generic one, which just basically mirror images the statute and says, please give us this, this, and this. That's one way to do it. That's not the way I do it. I want specifics, I want answers, and I want a record. And if there are very specific issues that the prosecutor's attention, and in certain cases the court, ought to be drawn to, then you send it to them that way. And again, you're building a record, you're documenting everything, and you wait and see what the response is and go from there. But, you know, there's a really large peanut gallery of people who, have opinions on these things. And that peanut gallery can include other lawyers, YouTube people. It can even include women who have nothing to do with anything other than they sit and watch on the couch in Indiana and have never stepped foot in a courtroom in their life. Everyone's got an opinion. They're entitled to it. But what I would simply say is, and most real lawyers would tell you the same thing, everything you do has a purpose and a reason in furtherance of what you're trying to accomplish. Some of it may not be apparent right away. Some of it I would think would be readily apparent by these kind of letters. These are very, at their core, simple demands. They're shocking to many because of just how bizarre the facts are here and are what are alleged. And if that somehow invites, you don't know what you're doing, real lawyers are not making decisions or making judgments or being influenced by, somebody sitting on a couch in Indiana or in an attic or elsewhere telling you how this works. I mean, everyone has a right to an opinion, but the lawyers generally handling cases of this magnitude have an idea of what they're doing, and everything has a purpose.
And also, we, have you and Attorney Bradel, who are, between the both of you, over 50 years of practice in New York and in the Commonwealth of Massachusetts. So it is, to me, it seems disingenuous at the very least for you, or for me even, to have an opinion about things that I am not a lawyer. There are certain things that I definitely do feel as though I have a firm grasp on legally, but I do not, I would not have any idea or concept of that, Attorney Bederow, to say that.
I don't agree with that literally, in the sense, of course you have a right to an opinion. Ladies sitting on a couch in Indiana have a right to an opinion. It doesn't mean she knows what she's talking about, but she has a right to an opinion, whatever. And she's, and like anyone else is free to share that and attack and criticize and mock, whatever. This is a sharp elbowed business. And when you, as both Tim and myself have done, prosecute in big cities with big cases and defend in big cities in big cases, it gets very sharp elbowed. That's fine. The irony is that in all of these situations that I guess are either the Karen Reed case or the cases that are kind of orbiting the Karen Reed case, the sharp elbows in that orbit are from the peanut gallery on Twitter, which is a whole new experience. Usually, you go into a tough courtroom in Manhattan or Brooklyn or Boston, wherever, you engage in the field of battle with tough lawyers, and that's where it's coming. And to some extent that happens here. But what's crazy here is the lunacy, if you will, the craziness, the just batshit craziness. I mean, I don't know what else to call it. It is coming from people who are keyboard warriors who seem to wake up and have nothing better to do from thousands of miles away or 50 miles away, wherever the case may be, and just have an opinion, which they are entitled to. But generally speaking, my opinion on a matter of, medical science is probably going to be a lot less credible than yours. When it involves matters of criminal procedure and legal strategy as to making discovery demands and things like that, with all due respect to some of these people, you don't know what the hell you're talking about or why I'm doing anything. So you're free to say what you want, but, get a grip. That's all.
And of course, and I don't mean, Mark, that they shouldn't have an opinion. It's like feigned, to me. It feels like feigned outrage, right? That like you even can wrap your mind around what is even happening. It's just that no matter what you do, the exact opposite is what certain people are going to root for, no matter what. It doesn't matter.
There is a craziness. I mean, look, when you get called, you're unethical, you're this, you're dumber than any 10 drunks in the bar. It's just bizarre. I mean, look, and there's a cast of characters. There's probably 10 or 15 of these people who have their own echo chamber, whatever. But in the real world, they're Twitter people. I mean, that their life is on Twitter or talking to an echo chamber, and they can scream and yell all they want. They have every right to do it. It is what it is. But the reality is it doesn't dictate what you're doing. And one should not assume that people who have no experience in this world or profession of what we're doing, because they, looked up some things on Chat GPT and looked up some other things online about, Googled what is Rule 17, that somehow means they understand the strategy of defending a sophisticated criminal case. If you want to believe that, you can, or, you can maybe believe that the people in the arena actually have an idea of what they're doing, whether you agree with it or not, and whether you win, lose, or whatever the case may be. But everything has a strategy and a reason. And usually 99.9% of the time, it's not for what, the Twitter ombudsman thinks.
I love that. That is, listen, when you said the man in the attic, when the first day that you ever said that, it changed my life. Okay. But now the Twitter ombudsman, I'm going to potentially bring that forward into my rhetoric of the Twitter, because I get eaten up all day, every day. Okay. Which is fine by the same, like you said, 10 people with also their 33 sock accounts. So I'm just fighting for my life, but it is what it is, like you're saying, and you have done everything for a purpose, for your professional standards of practice and policy. You know what you're doing. Now, is there any update that you would feel comfortable just to say you feel like you're in? Are we feeling confident going into November or December in theory is the upcoming trial, correct, for Turtle Boy?
Yeah, right now, as things stand right now, there's a trial on a district court, which is a lower court case, in December, which has a pretrial conference in November right now. The two larger cases, if you will, they have appearances, one in December, which relates to issues involving a search warrant or whether they have sat on seized phones for too long and whether there ought to be a remedy for that. And then, of course, there's the perhaps most interesting of all of this, an evidentiary hearing that is scheduled in January, at which the issue will be as to whether the special ADA that is handling two of these cases, well, three of these cases, as it were, is going to be forcibly removed by the court because he is a defense witness. And, and that case will involve calling all kinds of interesting people in this whole saga as witnesses to explore that issue, including the prosecutor himself. And look, having been a prosecutor, having had hearings involving from time to time prosecutors' conduct, it's usually never a good thing if a prosecutor is being called as a witness by the defense. Just generally speaking, that's not usually a good thing. But, it has to be fleshed out, and then the court will make a ruling, and then we go from there.
Okay, that is very good. Thank you so much for that. Now, I did want to ask you about slightly switching gears. There was what I believe to be huge news, which was noted by you and brought up by Ted Daniel from Boston 25 News. And this is regarding the no true bill for the Karen Read case. And it's kind of commingling as it is, involving Turtle Boy, but there was an egregious overreach and overstep, in my opinion, by Adam Lally after this no true bill had already been, come to, the grand jury had thrown it out, and there was still an allegation in that courtroom of Karen Read's first trial that was alleging that, in cahoots of Turtle Boy, Karen Read, and her legal team in disseminating information to the public. Can I have your thoughts on that, sir?
Yeah, well, there's a lot to unpack there. And
yes, let's unpack.
We can unpack because, certainly unpack what's in the public record. So it is a public fact, and this has been a fact for some time. So in many ways, it's been frustrating over the past few months to kind of bite your lip as some of these yahoos we've been talking about have been screaming and yelling about the imminent indictment and investigation of Karen Read and Aidan Carney for intimidating witnesses and whatnot. The reality is that case was dismissed by a grand jury on March 27th of 2024. That's a fact. And so you got to unpack this a little more. So what does a grand jury do, for those who don't know? A grand jury is literally a group of 20 people who are 23 in New York. It's the same, I assume, in Massachusetts, who get assigned to grand jury. There's no jury selection, by the way. You just get picked and dumped, okay? And grand juries they're really an out-of-date thing. They really don't serve the purpose that one might expect in the old days that they did. It's supposed to be a challenge on the power of the state and a check and balance that if a prosecutor wants to bring charges, you got to present it to a jury of citizens to make sure that this is okay. Okay. So, but when the way a grand jury works is it's one-sided. There is no defense attorney in the grand jury. There is no defendant in the grand jury. There is no judge in the grand jury. The grand jury is literally an arm of the prosecution. The only person running a grand jury or saying anything is a prosecutor, okay? And the standard of proof in a grand jury is not like a trial, proof beyond a reasonable doubt, it's probable cause. So it is extraordinarily low, and that's why there was the famous expression, which actually comes from the New York Court of Appeals Saul Walkler, who was the chief judge until he got kicked off for all kinds of things that is a topic for another day, for like stalking a woman and crazy stuff like that. Look up Saul Walkler. You can read about that. But the point is, he was
not a good Saul, a bad Saul.
He was a legal mind, though. Okay, as a judge, putting aside his weird issue. Anyway, it was Saul Walkler who famously said sometime in 1980, whatever, that a grand jury would indict a ham sandwich if the prosecutor asked it to. The point being, it's a joke. Okay, it is an absolute joke. Now, as a prosecutor in Manhattan, I probably, in the 5.5 to 6 years I was there, I would guess presented, this is a guess, maybe 150 to 200 cases to a grand jury. Every single one was indicted, and every single one would have been indicted literally within seconds. Okay, there's nothing to think. It's probable cause. It's not, but that's the case with other. That's not a me thing. That's a this is how it works thing. The only time that cases would occasionally be dumped by a grand jury were when a defendant would choose to testify, which was a very rare thing. But every now and then, defendant testifies, they kick the case. So, for example, in my career, I've had 3 defendants on advice testify in a grand jury. All 3 of them had their cases kicked, but they had a compelling reason to testify, and it's got to be damn good. Okay. The point is, when you take this grand jury of Karen Reed and Aidan Carney in March of 2024, what are you talking about here? You're talking about a woman who's already under indictment for the murder of a police officer, and every grand juror knows that. Okay, you're talking about an indictment of a journalist who's already been indicted for the very same crime that you're seeking to indict him and Karen Reed for, and a conspiracy thereof.
Yeah.
So if ever a deck was stacked for a grand jury to just push the buzzer and say, of course, there's probable cause.
Push it through. Yeah.
Okay. Well, guess what? It didn't happen. And I got to tell you something. That is the reddest of red flags. All right. If that was not a splash of cold water on the face of this district attorney's office to reevaluate perhaps our bias, our thinking, what are we doing? That would have been it. Now, you also have to understand, if you saw the leaks that came out or the news articles about the search warrants, search warrants they did would give you the best insight into why they thought it was appropriate to indict these 2 in the first place. And so what they did was they saw that there was contact between Karen Reed and Carney, like, Aidan, that's whatever. They were in touch with for however many times. I don't care if it was 100, 800, 1,000. There were allegations that she provided evidence to him. Okay. Now, that may be true or untrue, but that does not translate into intimidating witnesses. That's not a crime.
Exactly.
You still need something called evidence before you charge someone with a crime.
Yeah.
And if they tried to indict based on the fact that a defendant in a case who believes she's getting railroaded was communicating that to a journalist who was breaking the case open, that makes perfect sense to me. That happens all the time, by the way. And I remember somebody brought back an old tweet I did in January before I even knew these people, and said, it said, this is crazy. You don't indict people because, a journalist is getting information from a defendant. You still need evidence. And I think what I said was, this speaks more poorly, and this is before the indictment, that this speaks poorly of the DA, not Karen Reed and Aidan Carney. What are they doing if this is all they have? So as bad as that is, once that case gets no billed, there is no chance, 0.0% chance that Adam Lally does not know that. Okay. This involves a murder defendant that he's prosecuting, and it gets even worse. All right. March 27th was just a few weeks before Karen Reed was going to go on trial. So play this out.
Yeah.
They assume she's going to get indicted. I mean, at this point, Aidan is like collateral damage. They're just lumping him to dirty her to get the indictment. Okay, he's already indicted for the same thing.
Yes.
This is to get her.
Her. Yes. Extra charges on her. Yes.
He gets indicted in late March. What happens? Jury selection is in 2 or 3 weeks. Now it is front page national news that the woman who murdered her Boston police officer boyfriend is worse than that. She's also conspiring with a journalist to intimidate witnesses and is now under indictment for that. Imagine picking a jury as the defense attorneys with that shitstorm in the press, right?
No. Yeah.
Then you have another component to this, which is perhaps even worse or as bad. What do you think if she gets indicted, the next move by the DA is revoke her bail? Now they try to get her thrown in the can. She's under indictment for murder, and she's now indicted for conspiracy to witness intimidate and da 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 da. She belongs in jail. Why do they want her in jail other than spite, which is one of the reasons, but that's not the main reason. They want her in jail because they know this is not a good case. It's weak, as you can see. But if she's rotting in a jail cell for the next year, what does that do to your mindset about when you start dangling guilty pleas? I'm not saying she would ever take it. She probably wouldn't, and I don't blame her. But all of a sudden they dangle some kind of manslaughter plea with minimal time. I'm already in jail. It'll cover both cases. Do you think that makes her more or less likely, or any other defendant, to consider taking that? It makes you more likely.
Of course, because you're, listen, are you kidding me? If you're talking about the system and the problems in the system, Mark, of people being, and Karen was so lucky that she wasn't in jail and that she was able to get her bail. And if they had added that on, revoked her bail, and she is sitting in prison for a year, why wouldn't she say? They would have tried to break her spirit more than they already have.
Absolutely. And we haven't even gotten to the scandal part of this yet.
Ooh.
You're at the pre-scandal. It's all bad enough. Now here's the scandal, okay? Obviously, the man in charge of prosecuting Karen Reed for murder knows that she's under risk of getting indicted for something else, okay? There's no chance he doesn't know that. Everyone in the Norfolk DA's office knows that we tried to indict and it failed. Whatever, it happens rarely, but it happens. Not that often.
Very rarely. Yeah.
But so here's the problem. Now you go to trial, and this is kind of a nothing burger. It's done. It didn't happen. We tried. It didn't happen. So they have a pre-trial motion in limine they file about excluding any reference to, like, Turtle Boy type stuff, right? Did I lose you? You look frozen. Oh, can you hear me?
I can hear you. Can you hear me?
Yeah. So
I'm sorry.
They file a pre-trial motion to exclude any reference to Turtle Boy stuff. Now, my understanding is all sides agreed that's kind of an out of bounds thing. Okay, fine. So then something else happens that they don't like. Guess who gets a press pass to cover the case? The so-called non-journalist.
Turtle Boy, yes.
And there he is in the courtroom. And so some of the witnesses in the case against him, which I'm not getting into the specifics, as you know, are basically the same cast of characters.
Correct.
In the Karen Reed case. And the DA then decides to file a motion under the theory some of these witnesses are going to be intimidated if he's in the courtroom. Now that's pathetic. Okay. That beyond just, he's not going to bum rush the witness stand and whatever. Nevertheless, the DA makes a motion to exclude him from the courtroom. That's not even the point of what I'm making, but you have to look at the substance of the motion. This motion was made in May, I believe, in early May. Okay. I think I want to say about 4 or 5 weeks after the people who drafted the motion already knew that the grand jury no-billed charges for witness intimidation and conspiracy thereof against Karen Reed and Aiden, right? We know that.
Yeah.
In that motion, in what I would call very crafty language, the DA says something along the lines of, it is our belief that Karen Reed conspired with Aidan Carney and her own lawyers. Her lawyers are criminals. Okay, let's call it what it is. They accuse Alan Jackson and David Yannetti of being part of a criminal conspiracy with Karen Reed and Aidan to intimidate witnesses. Da 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 da. Now, this filing was a publicly filed document. This was not submitted under seal or impoundment, as I'm learning is something else you can do in Massachusetts, which we did initially with one of our first round of letters because it documented things that were not public. So we, out of an abundance of caution, submitted it under impoundment. They didn't do that. They publicly filed this document, presumably aware of the fact that the press could pick up on this. Now, Karen Reed is on trial. There is a jury. Now, they don't read the papers and all that. Maybe, maybe not. It didn't happen, but a reporter would have been well within his or her rights to print a story and say that the Norfolk County DA's office is accusing Karen Reed, Alan Jackson, David Yannetti, and Aidan Carney as being part of a criminal conspiracy to commit felony witness intimidation. That's a hell of a story. Okay? That's a big deal. And they filed that publicly, knowing it could have been reported while the jury was out on this case, with full knowledge that this had been presented to a grand jury and a grand jury had said no.
No dice.
And they didn't say that in their motion papers. They didn't notify the court of this. It's my contention that that filing, based upon the no bill that preceded it in March, it may very well be single-handedly the most sleazy thing that was done in that entire court proceeding. Because if that had been publicly reported, and if jurors or others had heard of it, and they hear that the defendant on trial is intimidating witnesses, and not only that, her lawyers are part of the scumbaggery too. And also this guy, Aidan Carney, who, as you know, what did the judge later let in? Now, I don't think he was mentioned by name, but what came in later through some of the witnesses? Oh, I was intimidated. And people, and if that, the jury had been aware of that and heard that, she's got dirty lawyers, she's dirty herself. And all this time, Michael Morrissey, who's ultimately responsible for anything filed in the name of the Norfolk DA's office, Adam Lally, who signed the document, Laura McLaughlin, whatever her name is, the other one signed the document, submitted those papers, knowing, or certainly should have known. It's insane if they didn't know, and I think the odds that are literally zero. Knowing that the assertions that they were making were purely to smear, and that a grand jury found there wasn't even probable cause for what we believe happened. This is scumbaggery at a high level.
Is there anything, Mr. Bederow, that, I mean, does it rise in your opinion and your legal opinion to any type of prosecutorial misconduct?
I think it's more disciplinary than I mean, it's not criminal.
Right. But is it ethically?
Yes. One could argue it's perpetrating a fraud on the court, not aware there is an ethical restriction against not alerting a court to all material facts that are relevant to anything. Obviously, it would have been material to know that a grand jury said no. Okay. Now, the part I'm mentioning it was kind of a throwaway comment in their motion, but the point is they put it in there in a publicly filed motion. And again, there's a reason things get included in these filings. That could not have possibly added anything other than the hope that would be publicly picked up and harm the defendant and prejudice her, because they would think that she committed other crimes, and she would also be prejudiced under the risk that the jury if they learned about it, they shouldn't learn about it. They're not supposed to, but things happen, might also believe that her lawyers are criminals, which would obviously prejudice her too. So it's a disciplinary thing. And, if I were her lawyers, I would be, I don't know what they knew and when they knew it, to be honest, about the grand jury and all this, but I would be absolutely handling this.
Yeah.
What happened with this grand jury and that motion 4 or 5 weeks later, whatever it was, is really underhanded.
Yeah. And, Mr. Bederow, I would say also that is huge. And I'm sure that Mr. Yannetti and Mr. Jackson likely maybe are behind the scenes now that this is, and I'm sure that they have known about it and that they're working on something. But as it related to pretrial as well, I felt as though, you could go back and see that this has been, in my opinion, a pattern of behavior from the Norfolk DA's office when it came to timely, presenting their evidence, getting their responses. They were not appropriately recalling when emails were actually sent to labs. This was an actual shit show, and it, but well, even in pre-trial. Go ahead.
I wish I watched at the time more of this pre-trial stuff, because it would probably be even more apparently bad. But I can tell you one of the things that I did see that jumped out at me is after they got the materials from the federal government and they had an appearance, and the defense indicated this is loaded with exculpatory material, Brady evidence. Everybody knows by now, evidence that favors the defense. And the district attorney's position was, we've reviewed all of this and there's barely no exculpatory evidence in here. Let me tell you something, okay? You could agree or disagree with how reliable it is, but exculpatory evidence is determined by the defense. They decide how to use evidence. Now, everyone can have an opinion whether something's exculpatory or not, but a prosecutor errs on the side of caution, okay?
Yes.
To classify the following as, not exculpatory, the ARCA stuff, which was in the federal papers. That is as exculpatory evidence will ever get. That is literally the quintessential definition of exculpatory. Now, the DA can say it's not reliable all they want. They can argue anything they want. But there was a report among those federal documents from a series of credible experts who said it's our expert opinion that, based upon looking at John O'Keefe's injuries and based upon looking at the vehicle that is the alleged instrument of death here, that accident, as your hypothesis, backing up in her 24 miles an hour, could not have caused the injuries that he had, nor did it comport with the damage on the car.
Correct.
That's just mumbo jumbo for saying we don't think she did it. That's exculpatory. The Michael Proctor text messages, which were included in that, exculpatory evidence also relates to credibility. That's when you see, for example, in these letters, what they call Giglio material. Giglio is just an extension of Brady. It's the same exact thing, but Brady related to literally exculpatory factual evidence. Giglio relates to credibility. Somebody's a snitch. Somebody got paid to be a witness. That goes to their credibility. That's favorable to the defense. Credibility evidence, impeachment evidence also has to be disclosed, okay?
Yes.
So the idea that Michael Proctor's credibility was not impeached or impaired by, don't worry about him, he's a Boston cop, looking for nudes. You could go on and on, bullying the ME or whatever it was to try to get changing the opinion. Don't give me the gift, give it to her instead.
Yep.
That is quintessential Brady material. Giglio, same thing. there are all these other things. So when the DA says with a straight face in court that we looked at all this material and none of this is exculpatory, once you see what's included and that's their position, the credibility problem is now is in the DA's office. You can't rely on what they're telling you because they're not being honest brokers. There's no way they don't recognize that that's exculpatory. Okay. And if they do, they got a larger problem in that office. And, maybe that's why they had to bring in a ringer for this. I don't know. But the point is, these are real issues regarding whether it be non-disclosure of material facts, non-disclosure of evidence, misclassifying things, as you said, changing timelines, making statements that turn out not to be true. When you're a prosecutor, any lawyer really, in court particularly, you have to speak clearly, honestly, and not only that, if you do make a material misstatement accidentally, you are ethically obligated to correct it. You can't hope nobody picked up on it. As an officer of the court, right, you correct the record. So there's all kinds of problems, with that office. But I will tell you, the grand jury, the no true bill, and the statement that they put in a publicly filed legal filing after they knew there was no bill, that is bad with a capital.
Yeah, I feel like we got the exclusive here and the comment, which is that is basically the largest red flag that has been waved by the Norfolk DA's office in the entirety of the first trial. We're not including our thoughts on pretrial with that, but this is huge red flag territory.
Listen, I could round up some old friends and current friends and colleagues from my days in the Manhattan DA's office, or people there now, people in the Boston DA's office, whatever. We could round them up and say, out of a combined all of us, how many cases did you ever present to a grand jury? And it would be in the thousands. And I'm pretty confident that to a man and woman, it would either be 100% indictment or 99.999%. Okay. The fact that they could not indict a murder defendant and an already under indictment and a journalist already under indictment for being in cahoots together tells you that the flaw is not in the conduct of Karen Reed and Aidan Carney. The flaw is in the analysis, thought process, and motive of the prosecutor, which is what I said in January in that tweet. They're the ones who look bad, not these people who at the time I would have assumed are just going to get indicted.
Yeah. And it's also it's frightening to me, Mark, right? Is that when we look at this and it shows the shakiness of the charges that were initially the 3 charges on Karen. And I feel as though if you even go back to now June of 2022, when they upped her charge from manslaughter to second degree, was it all in order for them to say, maybe she'll take a plea. Maybe she'll plea if we continue to push this woman. We've pinned it on the girl and we're pushing and pushing and pushing her into a corner till she has no other option.
A lot of people think that. And for me, it makes no sense. And it also show that if it's the way that the DA thought this through, then they're even worse than I thought, which, is not good. For the simple reason, this case involves, obviously a very well respected and loved police officer who dies in a bizarre circumstance, whether it's intentional murder, accident, whatever. I mean, he's lying on the front lawn with one shoe and, and throw up and all this with a glass in his hand or near him. It's weird. But if they thought for a minute that when the suspect, if you will, is a pretty affluent, generally speaking, successful, educated woman who is successful in the business world, is an adjunct professor, comes from a good family with some degree of means, okay, obviously intelligent, has a lot to lose, immediately is smart enough to hire a very good lawyer, okay, and then as the months go on, brings in, another like grade A level lawyer. if you're a prosecutor and you're thinking like that's a plea case, there is no chance that she's pleading guilty. None. I don't know what. And if they thought that, I don't know what. And if they also thought that she would just plead guilty and this will go away quietly, okay. Successful, attractive woman mows down loved, beloved, good-looking police officer found dead on lawn of another Boston police officer. Yeah, that's going to go away quietly. That is made for the media, no matter what. There's no way that this is not going to be a big deal. So I don't get that at all, that anyone could have even possibly thought for a second that this was just going to be, oh, you know, she'll just take a plea and it'll be over and that's that.
I was just kind of thinking to myself, if it was, for example, that Mr. Yannetti he has his theory after she's arraigned in Stoughton District Court on February 2nd, 2022. He's got the theory. He's pushing back. She is saying, I'm not giving in and I'm going to pay my bail. I'm going to pay for my legal team. And then I'm just thinking, I know when you're saying absolutely not, Kim, like they're not that bad, but if they did up that, because I'm looking at it, Mark, and I don't see where second degree ever came, because I know that the grand jury, did indict it, but at the end of the day, the only thing that was new was the voicemails. And those voicemails, I'm not 100% sure how you can make a ham sandwich out of pissed off girlfriend voicemails.
Because they have no judgment and discretion. Yeah. Okay. They are what they are. Okay. They're kind of screwed. Okay. This is a terrible murder case based upon a motive of, we had a little spat in Aruba and a couple of weeks later, this happened and I sent some angry text messages. But they have another problem, okay? So take away murder. I think everyone with half a brain recognizes murder doesn't really fit. But then they have another problem here. They're locked into this theory that she mowed him down at 24 miles an hour in reverse, right? And from what we're told, if you go in reverse, from what we're told, you and I have never gone in reverse anywhere near that speed, apparently. Right?
Never.
Like, apparently, if you're doing that in reverse, that's fast, right? That's yes. Like, okay. That they're screwed, because if that's their theory, even though they have no motive, they have no real evidence that supports anything, but that has to be intent, doesn't it? If you're backing up to drill the guy at that speed, most prosecutors would argue that shows the intent was to kill. Because she's just flooring it. Now, some have said that could be the tow truck driver on, backing it up, and that very well could be. I don't know. Mm-hmm. But they're stuck in between, and bad facts make bad cases. Like they have a shitty murder case with no motive, but they have a shitty manslaughter case because she's backing up too fast, which appears to be an intent to kill. This case stinks.
Yes. I love that, and it has since day one, so those are all the areas in which there are so many more questions for me than there are answers still, as it relates to the Norfolk DA's office, the Mass State Police. In my opinion, I feel as though when we look in comparison and contrast of Karen Reed and the tragic death of Officer John O'Keefe on January 29th at 34 Fairview, in the stark contrast of seeing, it's been almost 30 days now of Cadet Delgado Garcia being, losing his life in an alleged boxing incident at Mass State Police, where they state there is an 8-minute video and there are witnesses, which none of that was available with the Karen Reed, case. All they had was the word of witnesses that were not eyewitnesses and had no account of anything, just told them what they thought happened. And that was considered Bible to Adam Lally and the DA's office, in my opinion. If you listen to that arraignment and that indictment, you hear 15 minutes of Adam Lally talking about what Jen McCabe's testimony was and what she said in statements. It's shameful, but it's shameful looking at Enrique too, because how are we not any further today than all these people were, and they had this tied in a bow against Karen?
Well, I wouldn't use a comparison of Karen Reed's case to anyone else for the simple reason. If you gave a course in how not to prosecute a murder case or a homicide case, not even a murder case, a homicide case, which could be any level of, someone killing someone else, whether how serious it is. This case is the poster child for how not to do it, the way this first case was prosecuted. And if you talk to any prosecutors who are comfortable speaking about it, or former prosecutors, they'll tell you that like this. And the best evidence you have of that is they brought in a ringer to retry it. They kind of get it, I guess. Now, as far as the other case, I mean, the common link there is really the state police. But in all fairness, it's not Norfolk County, so you can't. Fair is fair. You can't blame that on Morrissey.
No.
You can't blame it on the Proctor, Buchanan, Tully cabal.
Nope.
It's not those guys. On the other hand, though, they've caused great damage to the whole institution of the state police. And, you have, for other reasons as well, there's a lot of reason to doubt their credibility of what's happening. And you have a guy who's now been dead about a month. And to this day, nobody knows anything. And, is that a good thing? I don't know. His side has been very, very quiet, which, that's fine. There's different ways if that's how they want to do it. It's a little surprising given that there's no information out there. The rollout of that investigation was really clunky. That first several days did not look good. The press conference by the Worcester DA was a little cringe for a lot of reasons. Nobody being in charge for a couple of days was not good for a lot of reasons, including, and you'll pardon the pun, but, the bad actors could get their ducks in a row in those few days.
Yes.
Forget the reference to the ducks, which is a whole nother story about, that's the case I would compare to Karen Reed, by the way.
Okay.
That's a better comp than Enrique. But I think with Enrique, you don't know. You just don't know how bad or who did what or why, whether this was a tragic accident or just a beat down. I don't know. But, the silence is deafening. But to me, when you say like, look what they did to Karen Reed with no investigation and just, Proctor, hey, he ordered a tow truck before he ever saw the car and never took a picture. That's all you need to know. You talk to any police officer who's good at what they do, and they will tell you that's a red flag that reeks of the fix is in, or at a minimum, the worst kind of thing a police officer can have, which is tunnel vision. That just reeks of,
bias. Yeah.
So they basically did nothing. And you could even remember Tully testifying in that case. I didn't need to go inside. I need to knock on the door. So what if a guy was wearing, shorts and one shoe in the middle of the lawn with a cocktail glass, and they said he was coming from the bar and he's dead on Brian Albert's lawn, and I knew he was going in there. So what? Compare that with, what happened to this gentleman with the ducks recently. Everyone's familiar. They spent God knows how much tax money putting that case together, where this guy, it's like deputy dog for a 36-page single-spaced report, multiple search warrants, pulling video, all the shit they didn't do in a homicide case involving the death of a cop on another cop's lawn. And then even in the other duck case, and in some ways, you don't have a 36-page report, but that's even more disturbing. The woman that they got, within 2 hours of a witness having direct access to the state police, which, by the way, that's troubling. Okay. When a local business owner who is a town politician has the state police on speed dial to complain about ducks. Okay. And the state trooper or sergeant, in all fairness to him, who is supposed to be working homicide cases and whatnot, is in a position to drop everything. Again, juxtapose what they did in Karen Reed's case, which is virtually nothing. To drop everything, pull video, interview witnesses, interrogate witnesses, give lectures about the First Amendment and this and that within the span of a couple of hours. But they didn't have the willingness or ability, when they found what they claim was glass or taillight pieces on the lawn, to go back and say, well, wait a minute, if there's one piece, let's dig for more. No, let's wait at each day. Let's wait for evidence to reveal itself. That doesn't make any sense. Now, something else I saw, or I didn't see, I listened. I was driving home from a Patriots game last weekend, and I listened to a show that Melanie and Will did, where they pulled some documents on the Brian Walsh thing.
Yes.
And I agree with what they were saying, which was they did good police work in that case. They did. The same cast of characters from the Norfolk State Police Homicide Unit did really good work in getting on to Brian Walsh quickly, but they didn't show any of that same ability or effort in Karen Reed, which I think the conclusion they were drawing, and I think it was a good one, which was, well, doesn't that kind of sound a little intentional, or there's a reason for that? These are not dumb people, but their investigation in the Karen Reed case is comically incompetent. Why is that?
Yeah. Yeah, because they're able to do the work. You're absolutely right. I did find it, though, a little bit concerning that even with Tully not providing information until it has been called out, and when you have been told that you have been caught, that is when you say, I'll correct the record. That you didn't have correct police reports. Granted, they had the right guy. And if Brian Walsh gets off on this, that is such a travesty. And it is such a shame for not only Anna Walsh, but her beautiful children, her family. This despicable if there is any terrible consequences that come because of what has happened in Karen's case, and that they can extrapolate and find out, though, that the Mass State Police have a bit of the Norfolk DA's office. I thought they have a little bit of the same shit, different case.
Well, here's how you turn it into a question, or, a class on philosophy and ethics and things like that. The whole purpose of what they call the exclusionary rule, where evidence gets suppressed if the cops violate the Fourth Amendment, the right to counsel, is that it's supposed to hurt. Okay. And the theory is, if we hurt you, you'll learn not to do it. That it's like talking to a child. There's consequence for misconduct. Now, again, here's where it gets philosophical. Take a case like Brian Walsh, who he's entitled to the presumption of innocence, but I don't think I'm going out on a limb here based upon the evidence against him. That guy is guilty as guilty gets, most likely. Okay. He's entitled to his defense. It doesn't offend me, but I'm familiar with a lot of the evidence against him, which goes beyond his ridiculously dumb internet searches. I mean, they've got him at the dumpsters. They've got he's cooked. But here's where it gets, the question of ethics and philosophy. Should he get convicted? Because if they commit misconduct in his case, but it doesn't matter, and he gets convicted, do the ends justify the means for these guys? And say, who cares? Now, I'm not saying this guy should be freed. I mean, he's almost certainly a sociopath or psychopath, murderer who belongs behind bars, almost certainly for the rest of his life. But that's probably not going to happen, meaning him getting off. So whatever, he's not getting off. Brian Walsh is not getting off because of Michael Proctor. It's not going to happen. You don't need Michael Proctor to say there's video of this idiot going to dumpsters, getting rid of clothes and things that come back to her. And no, forget it. It's not happening. Brian Walsh is cooked. But what kind of message does that send to the cops if they're cutting corners?
Mm.
Now, there has to be consequence for misconduct. Now, there are some people who would say, case that is the kind of case where it ought to hurt, and the hurt would be through the roof. I mean, a psychopath killer being released is the worst thing. There are some who would say, I don't really care how bad the cops were. This guy's a monster and needs to stay up. It's kind of like the OJ principle, right? I mean, OJ probably OJ was acquitted on a case in which he was almost certainly guilty, but then he got sentenced to like how many years in prison years later for some cockamamie nothing. He was not getting sentenced for that case. He was getting sentenced for the acquitted murder. And again, is that not supposed to how it's supposed to be? But as far as them cutting corners, leaving names out of reports in the Walsh thing, not saying it was videotaped, we'll have to see. But the reality is it's not going to impact the Walsh case. So the question is, more importantly, how's it going to impact these guys' behavior going forward?
Yeah. But well, and how would the disciplinary action go if it wasn't to affect, or you know what I'm saying, like them to make it hurt, but not bad enough that the family and that he's ever let off? Exactly. But what would some of those maybe interventions or things be for Mass State Police? Would you have any idea?
Well, I mean, the punishment has to fit the misconduct. I mean, so for example, if they conducted an illegal search of Brian Walsh's home, I'm making this up. I don't know whether they
Correct.
did or did. I'm not suggesting they did.
No.
The remedy is you suppress all evidence that was seized in that illegal search and any evidence that derived from it. What they call fruit of the poisonous tree in legal terms. If there was an illegal search of the famous iPad that led to all of these just what I previously called dumber than dumb searches, how do you chop up your wife and when does a body smell? The remedy would be to suppress that. But even if that were to happen in this case, he's still going to get convicted because with no body. Oh, there's been, just off the top of my head, because I know the people who tried these cases, including a very close friend, 2 cases in Manhattan in the last 20 years where they tried. If any of you remember the Sante Kimes case, crazy old lady and her son, Kenneth Kimes, in Manhattan, killed Irene Silverman on the Upper East Side, and they never found her body. And they were like mother and son grifters. Yes, there's that word. And they were sentenced. And then the other case, the famous one, you may have even seen on Dateline in 2020, Dr. Birnbaum, who was alleged to have killed his wife and thrown her out of an airplane over the Atlantic Ocean. They never found her body. She was convicted. He was convicted in Manhattan 20 years later without a body. Okay. I mean, she was a missing person, just presumed dead. You can try a murder case without a body. It's much
of course. Yeah. But I'm just saying, like, let's say, for example, now if we don't have a body, and let's say maybe Proctor didn't just look for nudes on Karen. Okay. Oh. Maybe he tried to look for nudes of beautiful, gorgeous Emma Walsh.
Totally. And I remember saying this months ago, that the first thing that jumped in my mind was, I mean, obviously we don't know at this point, but there are discovery demands in other cases, as you know, including ours, where we want Proctor's data, period, like full stop. And we don't want the Norfolk DA deciding what's favorable and what's not, because they don't have a really good track record of doing that. Let's call it what it is.
Let's be honest. Yeah.
So I don't think it's illogical to believe, and again, we're speculating, and it's important to note that we don't
allegedly
know.
We're speculating. Yes.
If he's joking and bragging about looking for nudes and I haven't found any yet, and I'm looking at his retarded client's phone and doing this and all that, and you're getting the thumbs up from your supervisor. Those are brazen things to do, and you probably have done that before if you're that comfortable sending those kind of messages in a case like the Karen Reed case, and Walsh comes after, I believe, but Walsh comes at a time where they don't know they're in trouble for Karen Reed, so they're not on guard yet. They're still in that
modus operandi that they were always in.
They're still in that, like, we're bros, we're cops, but we're all bros. I guarantee you there were no women on those text chains. Okay. And because they knew better, that would lead to the possibility of being outed. But if they were willing to laugh about looking for nudes on Karen Reed's phone, I don't know why, knowing, I mean, Anna Walsh obviously was an attractive young woman. I mean, just, it is what it is.
Gorgeous.
Given the way these guys were talking, why don't I think that he would be doing that? Now, it doesn't mean he did, but would anybody seriously be surprised at this point if he was looking for nudes and bragging about it? I wouldn't.
Nope. And like you are saying, Mark, it's that he hadn't been caught yet. So there wasn't that kind of clenching, right? Of pulling it tight really quickly, because this isn't something that happens overnight. The behavior exhibited had been going on for a long time.
Yeah, it's part of their culture, and that's part of the problem. It's part of the culture. They're all too close to each other. They're all bros, okay? And they're all bros with the prosecutors. They all donate money to Morrissey. The prosecutors all donate money to Morrissey. They all live in the same office. They all go to lunch together. They probably go out drinking together. And this is why they need to fumigate the place. And the people that are running for Norfolk DA coming up, they should pledge to say this model of prosecution needs to end. Okay, we don't need to have embedded state detectives who are living in a locker room in the DA's office, as opposed to some degree of professional boundary, and recognize that the prosecutors are going to prosecute, cops are going to investigate, we're going to work together. We can be friendly, but we're going to be professional. And you shouldn't be so comfortable with each other that you can brag about looking for nudes on, this lawyer who you hate, his retarded client's phone, and talk about getting gifts and talking about wishing her to kill herself and all that. Okay. The place needs to be fumigated.
I totally agree. And unfortunately, Mark, I have like a strong feeling about the entirety of Mass State Police, not all of the Mass State Police, because clearly I believe we have incredible men and women Mass State Police. That is most of saying.
You can't
vast majority. But what I'm not going to do is pretend that we're not deep in hell with this shitstorm that has been unearthed, and that there needs to be significant reset, in my opinion. Because like you were saying, in my mind, and even when I spoke with Heather Bish, who is the sister of Molly Bish, another tragic mishandling of justice, if you ask me, out of DA Joe Early's office. So that's why I don't give him all the grace in the world after I've seen what he's done to Heather. But with that being said, there is such a difference in even each county of the Commonwealth. Each one of those embedded, the Worcester office, Norfolk DA's office, Essex, Suffolk, wherever you are, Middlesex, like these are things that there should have been more streamlined approach to the training, to your standards of practice that is not available in the Commonwealth. That's bananas, because there's standardized practices for every other freaking, even nursing. We have like our nursing licenses, our boards, everything is the same guidelines in the Commonwealth of Massachusetts. Even if I'm working at a state-run facility, or if I am working for a home care agency, you still have the same bounds and training. And why is it not applicable to Mass State Police?
I don't know. And again, I don't know what the answer is, because look, and admittedly, it's different. When you dealt with cases in New York City, it's much bigger. Okay.
Yes.
And, the New York City Police Department is huge. And there are, there are 50 police precincts for every borough. And even then, every borough, has Manhattan North homicide, Manhattan South homicide, Brooklyn North, Brooklyn South.
Mm.
And the point is, you didn't have the same 3 or 4 detectives. I mean, you got a case, and the detectives that were on the case, depending upon geographically in the city it would happen. And there were so many different subdivisions in the city itself that, although you would know some of these people, they weren't embedded in your office. You didn't have text chains like the way these guys did. They weren't donating money to the DA. They weren't, it's just, they need to break this system. It's too close. It's too tight. It's too much bro culture, if that's the right word. And, hopefully these people that are running against Morrissey will push back and say, this is part of the problem. And Morrissey is part of that culture. It is what it is. And people should ask him, why are you taking money from Adam Lally? He did. We saw those records. Why are you taking money from, not much, but money? Why are you taking donations from the state police that you, in theory, supervise on an investigation? Right. Are these favors? Are they like sucking up to you? Are you beholden to them? Are they beholden to you? This is all part of what can potentially breed corruption. I say potentially because it doesn't mean donating $100 is going to make someone corrupt, but this is how it starts. It's not normal. Okay.
And an appearance of impropriety is enough for us to say, I step away from it. You don't want that.
You could be sanctioned in New York anyway, if you're a DA taking money from your subordinate employees. Like, you can't do that. You can't use them to help campaign for you. And I don't know if he does that, but they were doing this in Brooklyn years ago, and they all got in trouble, and there was a federal investigation for misusing government time. Who the hell knows what they're doing? But there are so many red flags about the way they do things. And at the end of the day, it's not surprising that it leads to, look at these cases. Look at, the Reed thing is a fiasco. The Birchmore thing is just a complete fiasco. I'll let others use words to describe Aiden's cases. I'll stay away from that. There are problems, I guess, to some level with the Walsh stuff, although I don't think they're as bad as people think. You have these rubber ducky things, which is just absolutely, honestly, I don't care what you think about that. When you have a state police homicide detective charging somebody with littering, you gotta reevaluate like your whole career. That's unbelievable to me. State police, state.
I know.
Littering.
I know.
That's the equivalent of taking a stick of gum from your mouth, throwing it on the ground, and getting arrested by the state police.
Right. And it wasn't litter either, like, not for nothing, but like, it wasn't like we could fight back.
You can get into the merits of the defenses. That's true.
Right.
But you threw that stick of gum in a wrapper, and you wrote on the wrapper, Colin was in the house, and said, hey, buddy, look what I wrote on this as I flicked this on the ground. You're in Canton, you're getting arrested for a felony, witness intimidation, by the state police. And you wonder why people say this place is a national laughingstock.
Yeah. Yes, it truly is. And then to see that a sergeant from the Mass State Police is going to different counties, right? You're leaving even Norfolk County, but if there are, residents that may have sensed other things, or you're being approached at your home, even if you're not in Norfolk County. So there are some questions. There are some serious questions. Look at this truck. Now, what the truck and what the duck? Is this an actual still shot of Rich? No, it isn't. But these are the things that, like, if they're going to make this a laughing stock, and the fact that you're all signing up and almost gleefully to see the responses, and that we're going to crack down on rubber duckies. Oh, yeah, we really need to have a serious talk about what is facing this Commonwealth.
I go back and forth, which is worse. I can't decide. I mean, on the one hand, it's the one case of this poor woman who was arrested again by a state police sergeant who works in homicide, who got a personal call from a town selectman. Okay. And then she gets charged. That's crazy. And I can't
Yep.
decide which is crazier, that or the months-long investigation into the Duckgate caper, where the town of Canton who wants to get an audit of their police department, understandably so, because they're spending apparently God knows how many hundreds of thousands of dollars, at least employing this one guy to do nothing other than, find the chief architect of Rubber Duckgate and execute warrants and dumpster dive and do all kinds of things to make this arrest of a 65-year-old, local business guy. Now, look, you can make every argument you want. Should you be doing that? Many people would say that's kind of dumb. Like, why would you do that? But felony witness intimidation and littering, the state police coming down and giving lectures about, look, it all boils down to, in this kind of stuff, the problem with the Massachusetts statute. I mean, and it's just the reality. The statute is so emotional. It's written. Most witness intimidation statutes focus on the intent of the alleged defendant, not the feelings of the allegedly aggrieved. The Massachusetts one is the exact opposite. If you become a protected witness, whatever that means, and everybody knows in these cases the controversy of how to do that. And a state police homicide detective says, well, that person's a witness, and they had their feelings hurt, which may be true, by the way. But if you look at other states, when they talk about witness intimidation, this is what witness intimidation is. If you testify, I'm going to break your freaking legs. That's witness intimidation.
All day.
I have a bag of money here. If you want to get stupid, that's witness tampering or intimidation. Same idea, right? An actual acute threat, things like that. But chucking a duck on the ground, again, whether you think it's stupid or not, and whether you think that it hurt the feelings. I mean, we're going to get in a debate over whether the town selectman's feelings were hurt or not. I mean, that's, whatever. That's what a trial would be for, I suppose. But putting that all aside, are you going to argue with a state face that this guy's intent was to intimidate witnesses and harass? Or he's just, being kind of a knucklehead and making a joke and or more importantly, expressing his opinion? Speech can take forms. It doesn't have to be the spoken word. Conduct can also be speech that's protected under the First Amendment. And, we could go on and on with this, but it's just the kind of thing where these are the serious investigations in Canton, not, the murder of a police officer, not the suspicious so-called suicide of a poor, abused, and
young pregnant woman. Yeah.
That kind of gets whitewashed and thrown under the rug. Nothing to see here. But, batten down the hatches. We'll spend every tax dollar available, both state and local, to get the culprits on the ducks. And, you also get concerned that, a lot of this prosecution for witness intimidation in Massachusetts, and, if you like the First Amendment, like people like I do, it's content based. Okay. If somebody was throwing ducks around town, saying Karen Reed is guilty, to somebody who is potentially a witness, like say Karen Reed, who is potentially a witness, are they getting arrested for witness intimidation? No. You've seen on Twitter yourself, you've seen threats made against Karen Reed. Okay. She's a witness or a potential witness or somebody who has information. She qualifies for protection under the statute. You have had people on Twitter saying terrible things about her safety, about her personal life, calling her names. That could cause someone emotional harm. She's a potential witness. Are they getting charged? You've seen people who call themselves journalists, call themselves towels, whatever they call themselves, screaming in her face, recording it on Twitter,
Yes.
saying, why did you kill him? Why'd you do this? Are you having an affair with the lawyer?
Affair. Yeah.
Okay. Could that be emotional harm? Why are those people not getting arrested? What? And the answer is it's content based. They are suppressing speech and criminalizing conduct because they don't like the message. And that's called content based selective prosecution. And that's what's happening again in all these things that are orbiting the Karen Read case.
Yeah, and I wonder if they're like, when we go back and look at even the Massachusetts statute that is regarding this, Mark, and the witness intimidation as it relates to feelings and hurting your feelings, basically, you feel emotional distress somehow. Like you're saying, though, this is not a personal safety concern, right?
Listen,
And
yeah, I hate to interrupt, but I don't want to lose this thought.
No, keep it. Go.
Take a reporter. I mean, listen, and for those of you, if you don't ever come to New York, let's introduce you to the New York Post, how they do it, okay? They ambush criminal defendants or other people, okay? Suppose someone accused of murder is walking out of court and a reporter just doing their job. Why'd you kill him? Why'd you kill him? What do you want to say? Why did you kill him? Did you do it? Da-da-da-da. Why, are you going to testify? Da-da-da-da. And that causes the defendant to say, oh, God, well, I'm upset and they're accusing me of having an affair, or and now I don't know if I should testify.
Yeah.
That's witness intimidation. Take lawyers on the internet analyzing a trial. Okay. Well, take the Karen Read case. So I think that witness had a terrible day on the stand and probably perjured herself, and she's coming back the next day. I heard that lawyer say something about me that he accused me of lying. I'm upset. I'm a witness. Am I witness intimidating? No. Under Massachusetts law, as applied by these people, yeah. Yes. The statute can't mean what it says, and that's why it's unconstitutional.
Well,
just wait.
And that's for everybody. Like, this is as usual. All I'm saying is that, why I raise my voice, why I have something to say as just a mom, okay, just a nurse, just a Kim, is that I know that Karen could be me. I could be Karen. I'm one night away from anything happening that could change the trajectory of my life, how I feel. And I have never had that kind of feeling of holy shit. This could go very left for any one of us. Okay. And in addition, you have to look at what is happening to Turtle Boy. Whether you like what he says or you don't, it doesn't matter. It doesn't matter at all, because he has the right to say it, in my opinion, And
let me ask you this. Let's put the shoe on the other foot. If he approached Karen Read during the pendency of her case, okay, when she is a potential witness, and had the opposite viewpoint, in other words, you're guilty, lady, and I'm going to run at you and I'm going to say, why'd you do it? Are you a cop killer? Can you tell, what do you want to say about this? Or whatever they're accusing him of saying 180 degrees to the other side. Okay. Is he getting prosecuted for witness intimidation if Karen Read says, excuse me, I don't like what this guy's doing? The answer is no.
Not a chance.
Okay? But he's getting 18 counts here. They tried to indict him with Karen Read there. They arrested him on other stuff. They're, doing all this other stuff as you see going on. And you have to ask yourself, is it because they're offended by his conduct or his viewpoint? And if you're getting prosecuted for your viewpoint, particularly as a journalist, on a matter of public interest, expressing an opinion, are those the kind of people who in America should be getting prosecuted? And of all places, Massachusetts, the cradle of liberty, if you will, supposedly. And that's what's going on here. And if you don't think that this is a problem, whatever they did to him, however bad you think that is, then you have the duck people. And this, I mean, what's next?
Spiral. Yeah, it's just going to continue. It will not stop.
They are out of control, and it is all with people who are pushing a narrative against the people that are charging them believe. Okay. And you take somebody like Buchanan. Okay. He's a witness in the case against Karen Reed. He's a witness in the case, literally an alleged victim in the case against Aiden. I don't want to talk about the specifics, but he's literally, you know, an intimidated witness. Yet he's the one running around interviewing these people, making arrests for this stuff and asking who, you know, did anybody put you up to this? That ought to scare the hell out of you. Okay. Because these people are suppressing viewpoints and arresting people who are contrary to what the people arresting them think. That's called tyranny. That's what they do in third world countries and the Soviet Union and places like that. And he's just one example. Any of the cops involved in this. Show me someone who gets charged for the opposite thing. Show me this person on Twitter who basically said, I think Karen Reed is dead. Okay. You saw those horrible tweets. And I know people think they know who it is or they don't. I have no idea. I don't really care. But why aren't they investigating who is that?
Yeah.
And that's troubling. Why aren't they doing that? No, because they don't have time, because they're looking to dumpster dive for who ordered the ducks.
Ducks. Yeah. Yeah.
So this is all content based. That's the problem here.
Right. Yeah. Wow. Like, oh, Mark, we could talk for 5 hours about it, you know? So it just is, it's a wild time.
Law school flash. This is the kind of stuff they talk about in constitutional law classes and even a class I took in the First Amendment 100 years ago. This is exactly the kind of stuff that they would talk about. And I mean, what's going on in Canton and Norfolk County greatly with all these cases is just, I mean, it's insanity. You just can't make it up. And what makes it all the worse is, you know, if you disagree with other people, look out, right? They're coming. They're going to attack you, your intelligence. They're going to attack your ethics. They're going to attack your physical appearance. They're going to attack your politics. They're going to attack your income. They're going to attack, you name it, all because
your family, your job, your everything. Nothing is off limits.
And here's the scandal. Here's the controversy. Because I actually think differently than you, and think that the way this all started was, I think the case against Karen Reed is profoundly weak. I think she's definitely going to get acquitted. And this was my view back then. And I'm pretty sure she's probably actually innocent, which I feel stronger about today than even I did back then. And I'm still waiting for the first person who will say, I hear you. I don't agree with you. I, in fact, disagree with you. And let's have a normal discussion about it. Instead, grifter, loser, unethical, hack, midget, you name it. These people are just, they can't debate merits. They get triggered by everything, even, you know, to bring it back to when you started, to having the so-called meal of food.
Yes.
So I'm just waiting and would love for the first one of them be normal and just express your opinion, have a discussion, and that's that. Without
and it's so awkward too, Mark, because I talked about this last night on my stream. If you think differently than me, that's your right. That's your prerogative. I'm not here trying to say shit to anybody else who does not agree with me. All I'm saying is what I say on my page. I don't attack anybody. And then when I get attacked, sometimes I do say things back. But here's the thing, is that I'm only defending myself after you've said called me every name in the book, told me I'm a fraud. I'm a piece of crap. I'm a terrible mother. I'm not a real nurse. I'm not this. I'm not that. I'm what all the names. I don't care about that necessarily. But at the end of the day, I completely just know my beliefs. I'm not trying to make anybody else come to my side and you must agree with me. No, I have plenty of people that I would never have a problem to discuss anything, but you're not going to tell me, you're not going to speak to me inappropriately and tell me that I'm a dumbass because I'm not listening to evidence that's not actual I don't believe is actual evidence that they're presenting.
Well, any 10 drunks in a bar, join the club.
That enrages me. That I get like I wanna put hoops on and a pair of Adidas for you because you that is so ignorant.
But you listen, you can fix many things, but you can't fix stupid. I mean, that was an expression told to me many years ago by a mentor, as a young lawyer. You can argue, you can debate, you can make a case, you can do whatever you want, but you can't fix stupid. And at some point, you do have to accept that some of these people or their positions, it's just not worth it. And when you get to that point, you block, you ignore, whatever. But, the First Amendment gives them a right to do what they want. And it gives you a right to be ignorant, to be an asshole, to be whatever. That's the beauty of America. You have a right to be a jerk, too. And if that's what you want to do, that right extends all over the country to all kinds of places, even, addicts, extends to Indiana, extends to Canton. It goes everywhere, anywhere you want.
Sure does. Mr. Bederow, would you do me the honor, good sir, if I read any super chats that came through just so that we could maybe answer any questions if I see them come up now? Is that okay?
Of course.
Okay. All right. Well, thank you so much, Sherry D, for becoming a new member, lovey. And also to BLT, my little bacon, lettuce, and tomato with a toaster. And Nicole D. Oh gosh, is this? Oh, look at this. Jenna Hags. That's my Jenna. I know her IRL. Charlie Lynn. And now we have Dewey says, gotta thank you for the chair spin yesterday. I belly laughed and I needed it. Dewey, I don't know what I was doing. Oh God. So, okay. Yep. I was spinning on Saturn and I spinned around in a chair. I did. Yep. Oh, Lord. Jenna Hag said, so excited for this because she loves Mr. Bederow. And I finally figured out how to subscribe. Thank you, Lovey. And don't forget to email me about the nursing stuff. She wants to maybe look into becoming a legal nurse consultant. And I am all about that. Do it, Jenna. Then we have Donnie, not Wahlberg. Incredible. Okay. Became a member. And do we have any, Lord, do I have questions here? Okay, we've got one coming up. I'm sorry, Mr. Bederow.
Important one on steak. I see that one.
Yes. Nurse Kim, are you an absolute, no, you are an absolute delight. Attorney Bederow, you are a class act. A bit Ben Matlock and a bit Perry Mason.
I like the Perry Mason part better than the Matlock part, but I'll take it. Thank you. That's nice of you.
Listen, you're everything in my mind.
I take what I can get.
Yeah. Okay, we're going to do that. And then we have Dewey said, next time somebody asks that get to know you question, or what historical person would you invite to supper? I will say Mark Bederow. Mark Bederow, who would you want to come from a historical person to supper? Who?
Winston Churchill or Abraham Lincoln.
Oh, I love that. Who would I want? Oh, gosh. Maybe Madame Curie or maybe Mother Teresa. Random, but I just thought of them. So we will do. Now we have, oh, nope. Going back up, not down. Classic Overthinker says, can you ask Mark his opinion about Karen Reed blood test extrapolated BAC not being admissible. Mr. Mark Bederow, Attorney Bederow, what do you think about the crazy unhinged message that Nurse Kim sent you that night that did not really mean anything?
You know, if you looked at this as a simple DWI case, which it's not, obviously, but if the issue here was proving intoxication, and they're relying upon this fakakta blood alcohol test, extrapolating it out, the problem is even if you get past the threshold of admissibility, it has to be reliable, right? And in any scientific test where you're taking blood alcohol, anybody knows this who does this for a living or has medical training in dealing with this. You have to, the way the body processes alcohol and all this, you kind of have to know, if you're not witnessing somebody drinking, well, when's the last time they had alcohol and what the effect could be over time. And that's why you have what they used to call the 2-hour rule to take a breathalyzer test. It became useless after 2 hours. You had to be under constant review to make sure that they weren't, putting mints in their mouth, drinking NyQuil, Banaka. Remember that stuff? All this stuff. Or burping, mouth alcohol, all that kind of crap. None of that applies here. But the real reason why this test stinks in this case is, what is the source of the underlying premise of when the timeline began or ended? Michael Proctor. It's what he said. And if you kneecap him, and that guy presumably is not going to be a witness. Maybe that's not the case. You can't assume just because of Brian Walsh that it would relate to the next one. But I mean, they're kind of screwed either way. They either don't call him or they do, and he gets kneecapped. I mean, he'll get killed at the second trial 1,000 times worse than the first one, because by then he will be fired or, hanging by a thread on top of everything else. But that test is useless without him giving you the time that she consumed alcohol. And you add in the fact that all the witnesses, forget the lawsuit. The lawsuit it helps her, frankly, on all of this. That's another story for another day. But all of the witnesses who are presumably against her and hate her, and you could go down the line: Brian Albert, Jennifer McCabe, Chris Albert, Brian Higgins, whoever else who are at the bars, all the other people, the Greek couple, the nice people, forget their the.
Yeah.
Wow, that was good. A lot of these other people. The irony is, to a man and woman, what did they all say? Looked perfectly normal. The other problem I think they potentially have is, and I'm not a math person, I went to law school, so I don't have to count for a living, but even with my limited math skills, I don't think the video from the one bar where they claim she took 9 drinks, I can count to 4 or 5 and I can count to 9 and I know the difference. I don't think it really matches up. And I think you also don't know what's contained in those drinks. When you get down to it, on a reasonable doubt standard, you're relying on this extrapolated blood alcohol content test that is perhaps scientifically dubious and relies on Michael Proctor in the first instance. And if you break the chain, the test is unreliable. I mean, any scientist will tell you, if the fundamental premise is destroyed, then I don't need to go any further. If I don't know when she last had alcohol, how can I extrapolate the test?
Can I ask you, can we go from the extrapolation now? So do you remember when I was blacked out and I was talking about that Worcester case that went to the SJC with but that I'm concerned because if you look at Turtle Boy's interview with the juror, never mind the extrapolation, Mark, we have a problem with the BAC that was taken at Good Sam. But I believe while she was, under a section 12 on a psych hold, and I can guarantee there is no consent for her talk screen. Guarantee you that. And if she came up at a 0.08, and that's where the jury went and said, Officer John O'Keefe is not alive. Karen was a 0.08 at 9 o'clock in the morning. I don't think she meant to do it, and they started to fill in and not follow directions. They were filling in holes of the Commonwealth theory, and my eye twitches every time I think about it. But the fact that some of them were able to get there on manslaughter and DUI, it was solely because of the BAC and the text stream data. So any thoughts on if we can suppress the BAC from Good Sam that morning?
Well, I'd have to, re-watch the evidence because I don't literally remember every detail. But if she's not in a position to consent, then you would have to get a court order to get, which presumably they didn't have, because you would know that. So it is an interesting argument. Now, the other thing is this. I don't know because I picked this up late. I mean, I only picked this up a little bit right around the time of the trial when, again, I was getting forwarded messages of Wendy Murphy wackiness, and that kind of did it. So I didn't see what was going on the months before. I assumed that the defense would have moved to suppress evidence, including this, based on a lack of consent or any other reason. I don't know if they did or they didn't, but
they did another reason. They did a testing. They went a testing route, which was a great argument in my mind. I understand exactly why Alan Jackson went with that argument, but and of course Bev didn't give it, you know what I mean? She said it was denied, but Lally also said that there would be no problem to have the phlebotomist or the nurse to come in and talk about how it was collected, the specimen. And we never heard from a nurse or a phlebotomist who took Karen Reed's blood. Only Justin Rice, the emergency room doctor, was called to the stand. And let's be perfectly honest, that man didn't recall treating Karen Reed or Officer John O'Keefe at all.
Yeah, no, that's certainly not what you'd call a reliable witness. I mean, he's not making it up, but who's going to forget more often than an ER doctor? I mean,
no one, every one of them. Yeah, I know.
It's just next in, next out, and they are emotionless. I guess they have to be. I mean, that guy was particularly emotionless, if I recall correctly, but it's just coming in, coming out. But the problem is, the pretrial hearings and rulings are made. They're done. I mean, they're not gonna relitigate that pretrial. So, unless there's a reason to, which I don't know why there would be. I mean, it's a settled question in the case, what they call the law of the case.
Yeah. Okay. I was just trying. I don't know why. I just was thinking because of that kid out of Worcester who got transported medically, right? And then once they drew the blood from the third party at the hospital, didn't have a consent, and he wasn't charged or arrested for a DUI or anything else at the time. So the SJC ended up overturning it and saying you can't use this in his case because you didn't do your job. You didn't read him his Miranda rights. Nothing had occurred prior to you sending him to the hospital where he broke his arm and whatever else, and he was being treated. And just because there was a subsequent finding of a tox of an ETOH that was higher than the legal limit, then you guys wanted to pile on.
It gets tricky. I mean, again, I'd want to know more, but I like the lack of consent. The Miranda probably is not applicable. She's not in custody. She's in civil detention, if you will, by, under a mental health law, whatever Section 12, whatever they have in Massachusetts. But, Miranda is for custodial interrogation. I don't think, now on the one hand, when you're Section 12, you're not really free to leave, but that's a civil commitment kind of thing, as opposed to you're not being held for a violation of criminal law. So it's complicated. I'd have to know more, but I mean, I like your thinking and it's interesting. And either way, though, to me, the real simpler issue is Proctor, and he's not reliable. Yeah. He's awful. And if he's not credible and not worthy of belief about the timing that she had her last drink, which he claims is based upon what Karen Reed told him. I mean, if Michael Proctor is an issue in this case, the defense is going to sum up on him and say, if Michael Proctor told you today that it's 7:57 p.m. on Friday,
Mm-hmm.
you should not believe him until you look at your watch and corroborate that, because anything he tells you without corroboration is not worthy of belief. And I
Totally
think
agreed.
the jury would find that about him. So how is he corroborating that? It's just him saying that's what Karen Reed told me.
Mm-hmm.
So I
Yeah.
think the DA's problem is a more simple one, which is they're losing witnesses, and they're losing. I mean, not that Michael Proctor was credible the first time, but he's worse the second time.
Yeah. Any thoughts on that too, Mark, just before we go move forward? Because I was really hoping for today, because I'm always expecting a data dump, aka a news story Friday afternoon in the Commonwealth of Massachusetts in regards to the Commonwealth versus Karen Reed. And I was thinking that something with Proctor or an update, because it's been we've hit it was July, August, September. It's our 90-day mark. So I was hoping that there would be some update from MSP, because that was not technically through post. It was through the Colonel Mon, who made that disciplinary action. Do you have any thoughts on maybe if it's coming next week? Is it not going to come for 6 months? What do we do? I thought they said 90 days.
Who knows? I mean, look, the police unions, and this is no fault. This is the reality. They're the most powerful unions there are, and even someone like Michael Proctor gets due process, right? And if he does, everyone should. But the reality is, I mean, he's done. He's useless to the state police. He's not worthy of cleaning the bathroom at the barracks. I mean, he has no value to them. And on top of that, there's a new colonel. Why would you keep this? I mean, you come in, brand new guy, you have scandal after scandal, right? You have all this Karen Reed stuff. You have 3 case troopers and supervisors under investigation of some sort. Maybe to some extent you have a Guarino issue that is a little concerning, although I don't think he's officially, not that I'm aware of anyway, under any kind of thing. You have this terrible thing with Sandra Birchmore that you guys are mixed up in. You have the Enrique issue, again, not Norfolk County, but just the police. You have a complete lack of confidence in the public in this agency as a whole. You have, what was it we saw the other day, 99 dropouts right before graduation or something. Are you really coming in as the new colonel, and one of your first acts is going to be, I'm going to die on the hill of saving Michael Proctor? He's toast. That's like the easiest decision to win over public respect, is to say, get this guy out of my sight. Right. I mean, and so, I mean, he's gone. I don't know when it's going to happen. But it's coming. The skeptic in you might say, do they try to drag it out as long as they can so that he's not officially terminated by the time of the second trial? Maybe. But, and what would the difference be there? Well, the difference would be there that is, if they call him as a witness, the defense attorneys, if he's fired, they're going to call him Mr. Proctor, right? And by the way, up until 3 weeks ago, you were Trooper Proctor, but you're not Trooper Proctor anymore because, and so on and so on. You could really,
hammer it home. Yeah.
Safe, proverbially speaking. But, he's Trooper Proctor, at least for now. And does that kind of thing factor in? I don't know. I mean, really, I would just trim the fat, let him get him out of there now. I think it's just a stain on the agency the longer he sticks around, especially with, they're in the process of reviewing all his data. At some point, there's going to be more disclosures. And remember, they're getting it from every idea. They're getting it from the Walsh case. They're getting it from our case. They're getting it from, other cases that he's involved in, maybe that doctor who, threw his wife in the lake or whatever, Reddington's case. I forget the name of the doctor. He's going after them. So at some point, he's just taken on too much water for them. And the simple thing is, you just let him go and hope for the best. And he's going to have to deal with the fallout. But, this is a you problem, not a me problem. You know what I mean? That's the state police's problem.
Totally agree. And then Kelly Reed said to us, hi, Kim and Mark. Happy to see you both. I have waited all day for this show. Justice is coming. Free Karen Reed and free Turtle Boy. Kelly Reed, I love your face. And I just wanted to say, you beautiful haired woman, you know that your mane is as luxurious as it comes. One of my favorite pictures is with myself, Attorney Mark Bederow, and Kelly Reed. And she looks like a tiny lioness. And I also wanted to say, I am so sorry that I didn't get a chance to wish you a happy birthday on your birthday this week. I will text you or I will email you later because I apologize. I had a family situation, but I wish you the best of the year.
You just said something that's interesting too. Totally unrelated. It's just an observation. It's like a Massachusetts thing in the legal community where they use like attorney as a formal title, where everyone calls you, Attorney Bederow, attorney this.
Yeah.
That's such a like weird thing to me because that's just not in my day-to-day practice. You're just Mr. No, in Massachusetts, they call everyone attorney. And when a lawyer is talking about another lawyer, they call him my brother. This is like, I really got to get up to speed on like Massachusetts culture.
That's weird. The brother thing. And listen, I've watched trials I've watched trials forever since that's a lie. But since I was probably like, I don't know, 15 or so, 18. And like that, you heard it once in a blue moon, but it almost felt like it was in pre-trial back in the olden days. And now you're hearing it all the time.
The first time I heard it was that we were having a bench conference and Robert Cosgrove called me his brother. And I just did kind of a double take, like, what? And then it occurred to me, no, he was being endearing. Just as I heard other lawyer. All right, I got it. That was just kind of
sister, and it's sister for like a lot. Liza will be sister, correct?
I guess so. I mean, we have I'm for Mr. and Ms. for addressing attorneys, but I'll acclimate. I promise.
Well, and that's hard for me because I either call you Mr. Bederow or Mr. Attorney Mark Bederow. I get wild with names for you. I do. I'm like, I don't know.
The whole like attorney in your last name. I'm not feeling it. That's not personal. I don't feel that.
Well, listen, I will never call you a name that you do not want to be called.
I don't care.
Okay?
It's totally meant as a sign of professional respect. It's just, but maybe that's because everyone in New York is just, mean and nasty. It's like, you're just Mr. and Ms. and no one cares.
They're like, hey, guy, come on over. No, Della Sanders said, Bederow, love him so much, so smart. You forgot something, Della, and handsome. Thank you, Kim. Okay, and my lover Romy with cheese says the entire Norfolk DA office is a red flag. I feel as though you are absolutely correct, Romy.
Well, there are two people running, at least two.
Yes.
And at some point they're going to have to consolidate. At some point, somebody's going to have to take the lead. Because of one against one, I would think that the gig is up finally. Yes.
After almost 40 years, right? No. I think it was 88 that was his last. His last. What is that called?
Private sector.
No. Like they had his last primary was in 88. He's run unopposed forever. That's
normal. You see that everywhere. And when you see it, and that, by the way, is what breeds a culture of corruption. When it becomes a system of unfettered power and you're collecting a huge war chest, even though no one's running against you, your employees are contributing and the cops are contributing. What kind of culture is that creating?
Yeah.
It's good. It's not good. And that's why these people come from the outside. They go after, the issues that we're talking about. And I think at this point, other than perhaps a few blocks of Canton, in every other so-called precinct of Norfolk County, someone else would win. I could think of a few neighborhoods in Canton where Morrissey would win like 98% of the vote. But other than that, I don't know why anybody at this point wouldn't at least say we need a fresh voice. Whatever you think, whether, you know, not everyone thinks that there's corruption. It is what it is. But, you know, there are other issues, I think, which he's made himself vulnerable to. I mean, the mere fact of bringing in a ringer to retry Karen Reed, to me, means only one of two things, neither of which is good for a DA running for re-election. It either means, number one, you can't find a single person in your office who's willing to do this because they know the case stinks to high hell, or two, you don't have any confidence in your own people, and that you have to use taxpayer money to go outside your office, because even though our taxes already pay for you to prosecute homicides in this county, you don't even have anyone
Even more offensive.
for you.
Yeah.
So
I
you can take either side of that issue. That ain't good for the DA's office and the use of tax funds, the competence of the office, the confidence in the office, and the confidence of the subordinates in the office in you as the leader. Because I wonder if there's people saying, I'm not touching this case with a 50-foot pole.
Oh, all day. Yeah, I would think. And then Calico Cat said, what about Bev saying the defense did a discovery violation with the federal stuff about ARCA? I think we talked about that a little bit, right? When we were talking.
What did the defense do with the discovery violation with ARCA? They got the material late. They weren't even allowed to interview them.
Well, didn't she say like why we did why we did voir dire was because Bev was
I think the voir dire was to see if they were qualified to be, you know, qualified as experts, to make sure they were up to the task. Now, the irony is they never did that with this, you know, Trooper Paul guy, who I think we can all agree, and I don't want to be mean, although I've probably said some not nice things about his competence. But to be, you know, to be candid, he's the worst expert witness, so-called expert witness I've ever seen in 26 years. So how that just kind of slipped in without any real vetting of him, why he was an expert in what, versus the ARCA guys who are, I mean, you know, they have obviously they're experts.
Yeah. And it was so, even when we went back to listening to Turtle Boy and him going through what the jurors thought, remember when they said that they thought it was potentially that Turtle Boy paid for it, or it was an insurance company, which I knew that there was going to be concerns with not saying where they were contracted from. But then I was like, everybody, let's use our brains collectively. That like Geico didn't send physicists who gave us their CV and like expressed where they had gone to school, their education, their background. No one's working for State Farm, Jenny, you know, or whoever.
The part that made me fall out of my chair in that interview, which, you know, I watched like everyone else.
Oh, of course.
The fact that ARCA had a little bit to do with it, but the juror said, well, we knew who you were and we talked about it. And like someone at home mentioned it, is already like, you can bring jurors back for that. Outside influence, ironically, you know, acquittal, no, but this, yes. But later on in the trial, she did allow evidence of so-called witness intimidation in.
Yes.
And if the jury knew who he was and had heard some of that, and then heard about witness intimidation, the risk is that they associate it with him, connect him to her, and it's not him that's getting prejudiced, it's Karen Reed that's getting prejudiced. So,
well, and that was so wild to me too, Mark, because if you go back and watch, it was a Jennifer McCabe's testimony when she literally said Turtle Boy's name, and then she said online, and this is when Alan Jackson snapped back and said, I don't have a Twitter. I don't have, like, you know, he clearly cleaned that up quickly. But she was allowed on the stand to insinuate not only Turtle Boy's name, but through her counsel in. And that was done right in front of the juror.
Yeah. The juror. Well, my recollection is, and this was bad, I thought it first started when it was actually the daughter.
It was. Allie did it first, but I don't recall that I thought that Allie said we've been harassed, and
but
I didn't think she named anybody.
Why? What? No, she didn't. But what she said, and if I'm wrong, someone will correct me. I don't think I'm wrong, but if I am, tell me. She was being cross-examined about Colin Albert and how,
Yes.
and you didn't tell the cops about Colin Albert. And then she said something along the lines of, well, he hadn't been mentioned yet. And it was only after it was in the paper and he came up. And that's about it. And somehow the court found that opening the door to harassment, which it absolutely did not. I mean, that was a terrible ruling.
Yeah.
She gave a pretty good answer about why. I mean, in all fairness to the witness, she said, I didn't mention Colin Albert because nobody said it didn't matter. And, it only mattered later. She answered the question pretty well. How that devolved into opening the door to intimidation and harassment, I've never understood.
I don't know either. Okay, and then we have another Lover-Romy with cheese says Morrissey wasn't looking for justice. He was looking for a quick conviction. He's completely corrupt. And then we have the Glairer. I don't know if he's still here, but Will, thank you so much. I'm sorry I didn't look on the side when I was talking to the one and only Mr. Mark Bederow. But we'll get him. We're trying to get him. And then Debbie Blair said, Mark, who is going to handle all this bad stuff, or who should handle it?
Well, if you believe by bad stuff, if you're talking about what people believe is corruption in law enforcement, traditionally that becomes the province and purview of the United States attorney in whatever district is where the corruption is occurring. And, that would be the U.S. attorney in Massachusetts. And I don't know what they're doing or not doing these days, but, that is the traditional person who would investigate corruption on a state level.
Totally. And Michelle Royce, thank you so much, Lovey. She says, let's go Bederow. And love your face, Nurse Kim. You look so pretty. Oh, thank you, Lovey. That is hilarious. It's my polka dot shirt that I would only put on. Look, I dressed up, and Mr. Mark Bederow dressed down. He said, Kim, you're my Patriot sweatshirt kind of girl. And I curled my hair.
I'm the kind of person who, when you get home from work, I try to get the suit off in like 7 seconds or less.
Immediately. Yes, if not sooner. And Romy says, I left my husband worse voicemails than that. Those voicemails meant nothing, in my opinion. I have said that too many times, Mr. Bederow. Do you have any opinions on the voicemails? Because if you, please don't ever let me be in trouble. Because if you saw text messages to Mr. Nurse Kim, or you've heard voicemails after being together for almost 19 years, we've had good years and bad years. And that seemed like a pissed off night to me. Nothing shook me about any of it.
I mean, look, couples fight. They obviously had tension in their relationship that went over a course of time. But if you somehow believe that evolved into the time, place, and manner in which I now have to kill you is after everybody knows I'm going to drop you off at Brian Albert's house and there's going to be a blizzard coming. So I'm just going to throw it in reverse and mow you down and leave, and no one will have any idea. That makes no sense to me. I don't think the messages were harmful. They are what they are. If anything, maybe they're a little embarrassing. It's airing dirty laundry in a relationship. But also, I think if you break it down further, the messages, if I recall correctly, started angrier and they got more concerning.
Yes.
And that actually favors the defense, not hurts. That shows like, why am I not hearing from this guy? Something feels like it might be off. So, no.
Yeah, and also, I've sometimes fought, which is like, again, I won't do it anymore. I've come to grips with not arguing, as not fighting back on Twitter. But with regards to people saying, why would Karen ever say that Officer John O'Keefe may have been, not alive or allegedly too. Now, after I've rewatched certain things, I don't even know if that conversation was had, but that's a story for another day. But as it relates to even thinking that he was potentially hit by a plow, I've said as a woman, and this, I mean it deeply, and people say, well, you're an actual lunatic. But there have been a couple of times in my life where I've had like an intuition and a gut feeling that's woken me up in the middle of the night out of a sleep, and I've been correct that something terrible has happened. If Mr. Nurse Kim doesn't call me, if my teenagers don't call me, I have immediate, like, the first place I go. This is my grandmother too, so don't be judgy. But my Nana Phyllis used to think if you didn't answer the phone, she'd say you were unalive in a ditch somewhere. She would think that, like, and am I an anxious human? Absolutely. But that's not out of the realm of possibility if your partner has always come home and now he didn't, and he's not answering the phone and he's not answering his niece.
All of this, see, to me, it all works backwards. Start with the premise of, this is not a trial of guilt or innocence. It's a trial of reasonable doubt or proof beyond reasonable doubt. And if you are in the camp that she did this, that's not the issue. The issue is there proof beyond a reasonable doubt she did it? And if you are latching on as your key argument and piece of evidence is, well, she said, could I have hit him? That is what I would call a supplemental fact that you kind of sprinkle on top of the ice cream for a stronger argument. Okay. And the problem they have is if you start from the other direction and work backwards, you have experts who say there's no car accident here. Okay. That's already, like, you're in the area of getting to reasonable doubt, and it flows from there. Well, if the experts are telling you that the taillight didn't get there in the way that the DA described, then that means it got there unnaturally. And unnaturally means somebody put it there. And then, who might have done that? Might it be these two knuckleheads who say, oh, it just revealed itself and we had no interest in looking day after day. We just found it. Sprinkle and again, you take the text messages. That's a sprinkle fact for the not guilty crowd. But just big stuff. And if they're hanging their hat on, I hit him, and could he have been hit by a plow? Those are facts you sprinkle on the ice cream. That's not if that's your number one fact, you're toast.
Yeah.
Never mind the fact that the I hit him is so much less compelling than these people present it. But
agreed.
Even if you accept it, you got to do better than that. You got to overcome the science and all these other things. They're using minor things for too much importance and not recognizing the burden of proof. And again, that's why a lot of these people who scream and yell, oh my God, she did it. You can think she did it, but you got to prove it beyond a reasonable doubt. And if these are your best facts, you're not even in the conversation.
Totally. And Lola says to us, Matt McCabe testified seeing the PD at an Asian neighbor's house. Was this ever confirmed? TB asked neighbors if the police department came by or checked a ring cam. All said no.
I don't know, but this is part of another, like, if you work backwards, fact to sprinkle on the main argument, which is the ARCA stuff. The conversations that these people had are incriminating. I mean, I don't know who did what in the house or whether anybody literally did anything in the house. But, when you look at this evidence of them having these weird text message conversations about they're looking over there, but they're at the Asian guy's house. What is Kerry's telling them everything? Don't tell them the guy was in the house. All of, deleting, forget the Google search, deleting other stuff.
Yeah.
Weird calls, the butt dials. All of that is weird.
Yeah.
Okay. And it's evidence of acting weird at a time that they should not have been acting weird. And it's really the prosecution's problem to establish that. And if they can't, what are they left with? But she said I hit him. I mean, that's, again, you can't fix stupid. If that's your primary argument, it's your opinion. Right. You're entitled to it, but it's a loser in a court of law. Sorry, sorry. okay. It is. You're never going to get convicted on that. It's just not going to happen.
Right. And Charlie Lynn says to us, thank you so much, Levy. I appreciate you. She says, hopefully you can demand exclusion of Guarino from doing extractions of KP, Mello, and Tully's devices. We cannot trust him. Is there any way that you can say anything about that, or no, Mr. Bederow?
Well, if they want to use him to attempt to extract and fail, it's their choice. The problem for him ultimately will be that whether he's allowed to be cross-examined on other cases about incomplete extractions. There are allegations about some missing things in the Karen Reed with Jennifer McCabe.
Mm-hmm.
Now they'll tell, oh, he didn't have the right software, maybe. Nevertheless, the defense found all that incriminating stuff. That's just a fact. Everybody knows about the 32,000 messages. Oh, yeah, but they found them on the computer or whatever. Well, maybe. But, Fanning submitted a report that said, I reviewed the extraction reports of the phones, both phones by Guarino, and nothing was there. I'm not going to say anything specifically about our case other than what's in the letter that was publicly filed a few weeks ago. It speaks for itself. You can agree or not agree. The point is, and this is fine because this is public, we're missing messages. That's just a fact, okay? How or who or what, that'll all get resolved. But so in all of these cases, things appear to be missing. So is it him? Is it some other reason? We'll have to see. But at some point, it becomes a problem for them that there's a pattern of possible confusion about why you can't rely upon a Celebrite extraction report. I mean, you can rely upon them in basically 99% of jurisdictions in America, but if it's a Norfolk County, Massachusetts State Police case, not so much. That's an issue. They may have an explanation for it, but you know what? That's an issue.
Yeah, and how many times can we continue to get the explanation is really the question. Yeah. And Tess says, thank you so much, Lovey. She says, Mark, we love you. All of our love from Canton. And a lover Romy with cheese. Thank you so much, my friend. She says, Richie didn't deny doing it, right? Why did they take his infotainment system information and investigate him for 6 months? Because I'm convinced they were trying to tie him to Aiden. Lover Romy with cheese. We're not going to have Mr. Bederow comment on that, but I think you're friggin' right. And and Richie never denied anything. Okay, that man has French bulldogs and a beautiful sign out of the front of his business. He has zero ability to bullshit, and he didn't do it at all, in my opinion. He said, yeah, and what are you going to do about it?
Again, they had all that evidence and whatever it is and put all these resources in. I won't comment on what the commenter said, but that's a very intelligent observation. But the point is, look at the resource, whether that's right or wrong, look at the resources they put into this and look at the resources they put in to Karen Reed with Proctor. I know she did it. We knew right away. I mean, Jennifer McCabe told me she hit him, so we're done here. Okay. Yeah. And that's one way to do it. It's not the right way to do it, but it's one way to do it.
It's the way it was done in IRL, not in a I don't know, a Columbo game, not in the game of Clue. It was done in real life. Okay. So Sumo says, thank you, Lovey, says, in Great Britain, in GB, we have CPS who have to permit all decisions of the police before they are allowed to charge. Is there not anything like that in America?
Wouldn't use America here. I mean, the problem is the jurisdiction. The way they're doing it here is the police are making all the decisions and they're sticking you with a summons in the mail and letting it get sorted out later. When you bring charges like this, accusing people of felonies for this kind of stuff, the better practice, of course, would be to consult with the DA's office or a prosecutor, like, the Crown Prosecution Service, as is being described there in the UK. But, here you have the state police and the Canton police just saying the hell with it. I'm going to write it up. And then, what do they say? A judge will sort it out later, but here you go. And that's when the cops are running the store, arresting people based on the content of their speech, and that is adverse to them. Literally, the individual is investigating, adverse to their department. They're taking all the heat. That's not how it's supposed to work in America. I mean,
Yeah.
it's just, this feels more like something that you would see, in the era of Stalin than you would see that you ought to be in Massachusetts in 2024.
Totally agree. And Charlie Lynn says to us, how is telling TB, I'll kick your face up and down this street or curb, whatever he said, from Chris Albert in front of D&E Pizza, not witness intimidation?
Because
that's an actual threat, isn't that? That's not I'll hurt your feelings. That's I'll break your face.
Well, there's a couple of reasons. Number one, the famous, forget it, Jake, it's Chinatown is number one. Number two,
bingo cards, anyone? No.
Exactly. Number two, it's content based.
Yeah.
Because it's on the wrong side of what the police, whether it be the state police or the local police, are doing. They're not going to charge people. Certainly the town selectman, who is a witness in all of these big cases and who is the parent of another key witness, or not, depending on your viewpoint in the case. It is what it is. It's how it works. It's how it's always done here. That's the Chinatown reference.
It's a Chinatown way. Okay. And then we have, I'm just kidding. We have, thank you, Katrina Shad, and I appreciate you, Lovey. Then we have Bukaki's missing dentures. Thank you, Lovey. I live in Indy and bought ducks. I asked to write on them. And so many people said, don't write on this, so you'll get in trouble. It's sad. Yeah, Lovey, just don't write on anything. Mr. Meathook says, question, Attorney Bederow. About 18 months ago, the New York Times restaurant critic trashed Peter Luger's for now becoming a mediocre steakhouse. As a respected steak judge, do you find any evidence to this calamity?
So, yeah, and you have to know the history. So Peter Luger is in Brooklyn. It's in Williamsburg, Brooklyn, and they, for many years, were the only steakhouse that had what I would call Luger style, this gruff. And when you would order a Peter Luger, it's how many. And that just means how many people are eating steak. And here comes the medium rare porterhouse with, schlag and all that, and big bacon and all of that. And then a lot of guys broke off from Peter Luger and started opening Luger style steakhouses in Manhattan, which were at almost as good food, but without the attitude. And of course, if you're a Manhattan snob like I am, you don't have to go to Brooklyn to go there either. And those places started becoming more and more successful, and people go to those. Wolfgang's is like that. Mark Joseph, if you know that, Ben and Jack's, they're all Benjamin Steakhouse. These are all essentially Luger type steakhouses. And there just became less reason to go, and they slipped. And, it isn't the same as it used to be. I mean, it used to be, if you came to New York, you got to schlep to Brooklyn, but you're going to Luger's. Like that was the quintessential. And I guess it kind of is. It's like a German beer hall atmosphere. It's a real old, very old school, and it's still Peter Luger. But they have one in Great Neck too, which is that's not, it's a minor chain at this point. But it's fallen a little bit, and you just don't go there like you used to. And I remember when the Times article came out, basically saying Peter Luger is more name than good food at this point. And yeah, no, that was a big deal. But you don't need to go to Peter Luger to get a great porterhouse anymore. That's the point. There's a lot more.
Where's your Manhattan's choice? Where's your favorite joint right now?
Right now,
you were going out with Mrs. Bederow tonight. Kids are being watched by Winnie and a real human. And where are you going?
For steak, I would go to Wolfgang's.
Wolfgang's. Okay. Now you know, Mr. Meathook. Katina Shadden says, I love your faces, both of you. Right back at you, Lovey. Then we have Just Us says, oh, I could listen to you two all the time. Believe in justice. I could listen to Mr. Attorney Mark Bederow all day, all night, and then I could fall asleep to his lovely angel voice. But myself, I actually hate it. But I appreciate you, Lovey. Then we have Gen X Gal 71. Thank you so much. And look at that doggy. Oh, that's a lovey.
A nice rock.
Yeah, nice little Roddy body. It is Saturday morning here in Australia, and I set my alarm just to catch this live. You are my two favorite people to watch on YouTube. My gosh, that's very super kind of you. It's just him. It's not me. It's the man.
Stop.
And then we have Charlie Lynn says, can you exclude Trooperino from conducting any further phone extractions? No, Lovey, we unfortunately cannot, right, Mr. Bederow?
They go at their own peril. I mean, if they want to use someone whose credibility is subject to attack for being incompetent, if that's the case, that's their choice. I mean, at some point, they're going to have to make a judgment whether there's a problem here or whether they believe that they can explain the problems that have nothing to do with the cops. That's up to them. The problem they're going to have in the Karen Reed case, if he gets attacked for this, is he's the one who is saying, well, the phone data shows that he couldn't have gone in the house. And, if he gets hurt on some of these other things, are you taking his word for that? He's also the one who said that the iPhone picked up some going up and down stairs on a few of these hills. And, look,
we were shake weighting it. Okay. That's what I equated it to. I said,
we all wear these things and we all.
Are you kidding me?
We all, and let me tell you something, if you have it programmed, it's programmed to make sure you get X many flights of steps a day. All right. And let me tell you something, there are times that I've gone up those freaking steps at Patriot Place, people, that.
Yeah.
I mean, that's gotta be 5 flights easy.
Mm-hmm.
There are times that for some reason or another, maybe that's like 2 or 3, I don't know, 4. There is no way driving in a car with a phone, just because you're holding it as GPS and holding it, and you go over a minor hill, is picking up flights of steps. And I'm a little surprised there wasn't more pushback on that, to be honest with you, because I think every juror wears an Apple Watch or has an iPhone and would say that's dumb.
Yeah, that's not accurate. Exactly. Maureen says, best show, Nurse Kim and Mark Bederow. Love you both. Love you back, Lovey. And then we have Cynthia Lynch, a super sticker. Thank you, Cynthia. Then Kelly Duck and Bukwaki. Thank you so much, Lovey. Oh my God, did you put a duck on your shoulder? I can't. I'm obsessed with you. Nurse Mama and Law Daddy. Ooh, back in action. Love your faces. Kim, are you going to have another in-person event? Yes, I will, Lovey. We'll talk about that another day. And Kim and Mr. B, what was your number one favorite thing from the KR trial? What would it be? Thank you and appreciate your breakdowns. Our favorite thing from the Karen Reed trial.
Well, I'm chewing ice. I'm sorry.
Yeah, well, keep chewing.
I think
my favorite thing
was the first maybe 5 seconds of the defense opening, because that's what you do. You follow a very drone-like, boring, falling asleep, convoluted witness by witness presentation of an opening that leaves you with nothing. Jurors are probably half asleep, and somebody comes out and takes out the baseball bat and just smacks everyone in the head.
Yeah.
And within 2 seconds, the place is transfixed. So from a lawyer, lawyers watch these things differently. That was great. I like that. That's what I mean, I could think of 100 more.
I could think of 100 too, but as soon as you said yours, I immediately, I'm David Yannetti. Karen Reed was framed. Opening line, opening statement. That was, I said, oh my goodness. I said 10 out of 10 would recommend. This man is on fire. I mean, David Yannetti, first of all, I love me some David Yannetti, but that approach and that open was I think of any case that I've ever watched, and of course you're like, you are an actual legend and a god of like defense attorney. But for me, watching things, hearing that and hearing his delivery was impeccable, I thought.
Yeah, no, and I mean, you could pick
Oh,
20.
go all day. Yeah.
You know, I liked, you know, shame on you, sir, because that's kind of my way I think those things too. I mean, and you know is that technically something you should be saying? No, but it's so appropriate. And again, part
Ask
of
for forgiveness, not permission, right? Like he had to get it in, and then
you had to let the jury know that I am repulsed by this, that this is not, you know, paid hired gun. I am literally repulsed that we just heard, and I want to make sure everyone else knows that. So, you know, I would say, I mean, you could pick 100 more things, but I think that those were each of their moments that I like.
Beautiful. And too blessed to be stressed says to us, in my opinion, Paul O'Keefe is involved and knows what happened. He's in cahoots with the Alberts. That's why he still says Karen is guilty after given the evidence. Well, Levy, go ahead, Mr. Bederow, on that.
You know, look, anyone who's a victim of someone who's died and someone's charged with killing them, you know, you got to give them a wide berth, in my view. Don't forget, they've been fed a narrative for all this time. Sometimes they just can't let go. I don't know if this is personal with Karen or not, and him, and or what it is. And I know there are some things that people have said that the family has done that is not great. But at the end of the day, you know, I don't really share opinions about family members of someone who was killed. They get a wide berth. There's all kinds of thoughts, and I don't know what's going on in their heads. I think he's misled. I think he's wrong.
Yeah.
A lot of things, but I'm not going to get into
Me either
on that.
Yeah, and I'll just say to you, Lovey, you're you know, absolutely, that's an opinion of yours, and I just would say that this also has evolved for this family, and it feels, I think, that I always try to say Officer John O'Keefe is not here. That was his brother. That is his mother. That is his father. And I don't really touch them at all because it's not my place to. I don't live in their shoes. All I know is my opinion on the case, and it has nothing to do with them, and especially when Paul wasn't there. I think he definitely has been influenced by some people who were witnesses. But other than that, I think that they were fed, you know, a narrative and believed the agencies in which their brother served for 16 years as a Boston police officer. Of course, you're going to believe the DA. Of course, you want to put all your eggs in the basket, and you have to blame somebody. Somebody did this. And I think it's easier to look at Karen as the villain, in my humble opinion.
Yeah.
Oh, sorry. And Della Sanders says, love you, Kim. I've had a mental crush on Genius Mark since day one. Mr. Bederow, you and I, when I say you're coming on, they're like president of the fan club. It is, but I am not just a fan. I am also, I sit at the table, right, Mr. Bederow?
You're sitting at the table.
There we go. And Maddie Wag says to us, love this dream team of Nurse Kim and Mark Bederow. You are brilliant. And we are so grateful for Mr. Bederow and so moral and dedication to justice. You really are, Mr. Bederow, and not to just, you know, kind of hype you up or make your head large so that you can't walk out and see your family after this. But when I met you, it was...
Hi, buddy. Just letting you know.
Well, no, but I sent you.
That's all right. Go ahead.
That's all right. But I sent you a text message the next day after we had supper, and I said that, you know, they say don't meet your heroes because people will let you down, and to me, you are somebody I very much look up to. I appreciate your insight. I appreciate your kindness, your humanity, your brilliance. And I just think you're a stand-up man and a human being, and I appreciate you for being my friend. So I wanted to say that.
That's very kind of you. Thank you.
Of course. And then we have, oh my goodness, Miss Parks is in the house, says, sending you this message just to say hello and tell you guys how much I love each of you. Beauty and brains on both sides of the screen tonight. I love watching each of you call out these bad actors in your own special way. Yes, mine is unhinged, and we have the professionalism and the years of knowledge, the expertise of Mark Bederow is, second to none. And that's why I enjoy it. I would love to do, I'm telling you, Mr. Bederow, if we ever get a case that we can do medical records on, and I just let me be an intern, I'm available. You know what I'm saying? I would always. Kelly Steffi says to us, thank you very much. My bestie, and he, BF, and her BF came to shelter at my house. Oh, for the hurricane. He never heard it before. I showed Trooper Paul's testimony, and he said she was framed. Oh, well, first of all, I'm so sorry for your friends that are sheltering from the hurricane. I hope that they are safe, and I hope that they are able to, rebuild, and that they're in our prayers. And I hope that the damage was not too terrible where they are, Lovey. But yeah, if you see Trooper Paul's testimony, in my opinion, that is as close to a Commonwealth complete blunder that I saw throughout the whole trial.
Well, that's another damned if they do, damned if they don't. They're bringing in this guy to retry the case. He's a real lawyer. He's got experience. On the one hand, you can't call this guy. I mean, it's embarrassing. First of all, I would never prosecute this case and blah, blah, blah. But if I'm him and I come in and say, this guy's out of here, I'm not using him as a witness. But then you have the similar problem that we talked about with Proctor, which is, well, if I don't use him and I get an expert, what happens when that expert has an opinion that is 1,000% different than Trooper Paul, but she's still guilty?
Mm-hmm.
The defense is going to pound Trooper Paul over that expert's head on cross-examination and in summation and make it clear that this is just a fiasco. This is like rent the witness for any given trial, and they're just looking for whoever. And, they need someone who is on the level of ARCA intellectually and who has an opinion that this is the burden the DA is going to have. They can't just cancel out the ARCA guy because it's almost per se reasonable doubt, almost. They need an expert who has the credentials that the ARCA people have, and above and beyond that, totally discredits them to the point where that doesn't make any sense. And if they can't do that, they can't win the trial. It's that simple.
Yeah, totally agreed. Miss Parks in the house. Thank you again, Levy, says, hell is not hot enough for any of these bad actors. Yes or yes? Yes. And asking for a friend. Thoughts on second trial, counts 1 and 3, obviously no crystal ball. How do you think November's going to go?
It's interesting. I think they've really made a strong argument for extending the law. And, sometimes the law does evolve and new principles come out. And I think the idea that in this situation, that this isn't something that jurors ought to be brought back. The only warning is, I think if there's a ruling that's favorable to the defense, it's going to screw up the trial schedule. Because I think that ruling would be, we're sending it back for a hearing to take evidence. And then the judge has to redetermine after that evidence, and then we'll go from there. I think there's still no finding. Forget whether you call it an acquittal or 12 jurors who said this is what we wanted to do. There's no direct evidence of that. There's certainly, it seems obvious that they 12 out of 12 acquitted, or in their mind acquitted, whatever you want to call it. But you need sworn testimony to make that finding a fact. And I think this is very messy. The irony is, if the DA wins, I think you're going to learn a lot about this DA's office, because they can't retry a murder case. Okay. And if they fight like hell and win to keep this murder case as part of the case, only for the new guy to come in and say, the hell with this, which is almost certainly what he'll do,
Yeah.
then what they're telling you is this is just a game to bleed her dry, extend this out, use up resources, waste their time fighting this crap instead of the trial crap. And if they waste all that taxpayer money, time, and this to try to win on principle, only to say, you know what, forget it. I'm not going to try her for murder anyway. They're just making a mockery of this whole process. And you know what? If they win, wait for it. It's probably going to happen.
Oh, okay. What do you think? Like 50, like, what do you think? Like, do you think it's like 90-10 prosecution's winning?
No, I think
it's a shot in hell that we actually get.
Yeah, no, I think there's a shot. But again, the ruling that I would predict, if it was favorable, is a hearing, not a ruling on the merits to say we find that this violates double jeopardy. I think the ruling would be send it back, remand it to the lower court to have an evidentiary hearing, and let's find out
Call those jurors. Yeah.
And then I think you also need to know that everybody seems to be blowing over this part of the issue is if they all come in and say, look, we acquitted, I think you have to ask the question fairly, well, why the hell didn't anybody tell the court? And the answer may be very good, but I think you need to know if everybody's jumping up and down and saying there was an acquittal, well, why didn't anybody tell us? I mean, I'd want to know that if we're supposed to believe this, and I do believe it because it seems clear that that's the case. But I think you need a better factual record than they have right now.
Absolutely. And last but not least, Dewey says, do you think Lally delivers that way on purpose?
What do you mean delivers?
I don't know, but are we thinking like what, if any?
Oh, you mean like that and time to make the donuts?
Yes.
I think that's who he is. I mean, whether you like it or not. Well, let me, this will be interesting. Let me give a slight defense of Adam Lally for a minute.
Okay. I'll rebuttal.
When you are on direct examination, meaning you're calling a witness, you can't use leading questions. That's for cross-examination.
Mm-hmm.
And one of the easiest way to avoid a leading question, which is only a question that suggests an answer, how fast were you going when the light was red? That's a leading question, right? Things like that. The way you avoid that is you say, who, if anyone, what, if anyone? That by definition is not a leading question. But the problem is he uses that crutch for 98% of the time. But the criticism of that was a little much because it does avoid leading questions. It just gets out of control when you hear it again and again, and it devolves to the point of who, if anyone, was driving the ambulance. I get it. Like now we're entering, crazy land with what are we doing here? But I think he does it on purpose because I think that's his personality and who he is. I don't think it's a tactic. Is he trying to put the jury to sleep? I don't think he's trying to. I just think he does. I think it worked out to their advantage, given that they called 857 witnesses. Or what felt like, 8 months, and there's no readback in Massachusetts and all these other things. And the judge limiting the closings, I think in hindsight really hurt the defense, given that there is no readback. So, but do I think he did it on purpose? No, other than that's who he is.
Absolutely. And I think that his smoking every day, I think it increased throughout that trial due to what, if any, increase from 10 to 20 cigarettes per day. And I don't know if he was smoking Parliaments or Marlboro Reds, but he was the poor guy is going to get himself, I want him to just take care of his health seriously.
That's another thing, like in this first trial, I mean, and you just laugh at this office. Whatever you think of the case, obviously I have a very strong view. I think the case against her stinks.
Mm-hmm.
I think she's certainly not guilty in a legal sense and almost certainly factually innocent. That's just my view. But if you're going to try this case as a DA's office and you're going to call however many witnesses, as absurd as it was, the trial was like 6 weeks or whatever, or 3 months, whatever the hell it was. I can't remember. It's so
9 weeks. Yeah.
Crazy. How do you not have a co-pilot. And I don't mean somebody with them to just sit there and take notes and do nothing during the, I mean, how do you not split up the witnesses like the defense did? How are you not having a trial team in the sense of, I'll do these witnesses, you do these witnesses? That's what lawyers do in most normal places. And to put this on one guy to literally do everything.
One man show. That was wild.
That is absurd.
Yeah.
And he did look
but
like.
McLaughlin could have done it. There was no reason why.
Why? I don't know why she didn't. You know, she made a couple of oral arguments outside the presence of the jury, but, you know, why didn't they give him a trial partner in a classic sense? I don't understand.
I don't know. Well, on that note, Mr. Bederow, I have kept you for 2 hours and 50 minutes. And we did a wicked long stream. I'm super sorry about that, but I love talking to you. And thank you for answering my FaceTime when I call you.
Of course. Come on.
Absolutely. Well, again, and listen, don't be a stranger. I know you're very busy. I know that you are doing, you're doing a lot work-wise with your family, everything else, but it's a pleasure as always. I appreciate you so much. And maybe you're going to get a different, at least put the Celtics on, because the Patriots are making us all unsettled right now. Okay.
News is today is what? Today's what? The 11th?
11th all day.
Oh, 11 days. Celtics will start. They'll raise the banner. They'll get their rings and it'll start. So that'll be exciting.
Absolutely. All right. Thank you so much, Mr. Bederow. I'll talk to you soon.
Bye.
Bye. And lovies, that was it. Okay. We did what I believe is 2 hours and 51 minutes with a living legend, with my best friend from New York, who literally is a mentor, who has taught me so much, who did such an eloquent breakdown of Brady and legalese tonight. This is why, you know what, we should send him messages, Attorney Bederow, that we believe he should be a teacher because he is everything. And he helps us learn. He breaks things down in a beautiful way. And he's an overall one of our favorite humans, right? We love him. Okay, so I'll let you guys go. Thank you so much for sticking with me. I love all of your faces. Thanks for answering my FaceTime. I'll see you guys soon. Bye.